repeat that. I'm going to open the meeting of the Harwich Conservation Commission for April 7th, 2021. This meeting is being conducted by remote participation, and I'm going to read a statement from Governor Baker's office pertaining to that. Pursuant to Governor Baker's March 12, 2020 order suspending certain provisions of the open meeting law, Mass General Law, Chapter 30A, Section 18, and the Governor March 15, 2020 order imposing strict limitation on the number of people that may gather in one place, this meeting of the Town of Harwich Conservation Commission on April 7, 2021 at 6:30 p.m. will be conducted via remote participation. Specific information and the general guidelines for remote participation by members of the public and or parties with a right and or requirement to attend this meeting can be found on the Town of Harwich website at www.harwich-ma.gov. For this meeting, members of the public who wish to watch the meeting may do so via recording on demand on the Harwich Channel 18 website or on our Town of Harwich YouTube page. So thank you again for your patience. We're going to begin with our regular agenda. First up, we have a notice of intent for 5 C Street, map 7, parcel D22. It's a proposal for new dwelling. Is there a representative here tonight that wants to speak to this project?
Please enter your access code.
Hi, Mr. Wall, how are you? If you want to hit *6 to unmute yourself, Mr. Wall.
To enable audio control, please enter your audio PIN followed by the pound or hash sign. If you do not have a PIN, just press pound or hash. This conference will now be recorded.
Let's see, all you callers that are unidentified, please mute yourself. Caller 8, caller 6, 4, and 7. Anybody who's not speaking, please mute yourself. And then Mr. Wall, go ahead when you're ready.
Thank you, Mr. Chairman. I had trouble unmuting myself, but here I am. Thank you, Mr. Chairman. For the record, my name is Brian Wall. I'm an attorney, and I represent the applicants, in this case, Walsh Brothers Building Company and the estate of Jones. With me tonight is John O'Reilly. Also on the panel tonight, Mr. Wall and the Jones family members are watching. They're not going to participate, but they are watching. So, Mr. Chairman, this is a consent hearing. We made a full presentation to the commission back on March 3rd. Mr. O'Reilly went through the project, went through what our position is as far as the compliance with performance standards. I discussed the delineation that we're relying upon. And basically, I'm sorry.
Now, go ahead, I can hear you. I think we still have some people that need to mute themselves. Everybody who's not speaking should mute themselves now.
Thank you, Mr. Chairman. So essentially, what I was able to say, after we gave a full presentation, also the abutters represented by council and wetland scientist Arlene Wilson gave some information. It was turned over to conversation and discussion with the commission, but because there is pending litigation, the first commissioner who made a comment felt uncomfortable about discussing it, and basically the rest of the commissioners kind of fell in line. So we never really actually had a back and forth with the commission. And so I would simply ask the commission how it wants to proceed at this point, and we are here available to answer any questions. We did submit written materials to respond to comments that were made by the abutters, and Arlene Wilson has also submitted a letter back in reply. So I think the commission has full information, and we're interested to have a back and forth with you.
All right, thank you, Mr. Wall. I think for myself, I'll just start off by saying that this project has been before us for some time, and it's coming back with an adjustment on the footprint outside of the 0 to 50 no disturb zone. However, myself, speaking, for myself, I have still concerns about the impact of this structure, this proposal on the coastal dune, on wildlife habitat, and potential introductions of pollutants due to septic treatment on the site. So I have concerns with this project, and I also have concerns about a 2009 wetlands delineation, whether that's still an accurate delineation. So those are my concerns. I just want to put those out there up front. And what I'll do is I'll I'll go through comments and questions from the commissioners, unless you have any rebuttal to the points that I just made.
Well, I think that we can discuss some of those concerns that you made, but let me also say something that I want to bring to your attention that is in my written materials. So we have submitted additional information regarding the 2009 line that we're talking about. And I know that your counsel, Attorney Quessel, is online, and I presume she's discussed this with you. So 2 points, Mr. Chairman, and I'll be very brief about it. Let me just briefly go through the history with regard to the delineation. So in 2009, the commission reviewed a project on C Street extension for drainage works, and they approved a delineation, and that is the delineation shown on the plan before you. In 2011, Walsh Brothers filed for a notice of intent for a house on this lot more seaward than the current location. This one is pulled more forward to the road because of the zoning considerations that we learned of. In 2012, the commission denied that project, and Walsh Brothers appealed. During the appeal process, the argument was made that because that 2009 permit that the commission approved was in effect, Walsh Brothers was entitled to rely upon that. And I want to make this point very clear. The parties to that appeal then settled the case. They reached an agreement. And the parties include the applicant, the Conservation Commission, and Mr. Reed, Mr. Reed's clients, I should say. And in that settlement agreement, it was agreed that the applicant was entitled by the regulations to rely upon that 2009 delineation. And a superseding order was issued by the DEP in 2015, predicated upon that 2009. That permit would have expired in 2018, but it did not because we requested an extension, and it's still valid. So the very same argument applied in 2012, and all the parties agreed to settle this case and agree. And I should say when they settled, it wasn't a compromise. Still, someone's still not moving. There's a lot of noise in the background.
Yeah, caller 6, caller 9, caller 4, and caller 7. I'm going to ask you to leave or mute yourself. Caleb, can we mute them independent of them? The same with Cape Chicks. Your microphone needs to be muted.
So in any event, Mr. Chairman, the simple point that I'm trying to make is this, that when the parties agreed in 2012 that the 2009 delineation could be relied upon, the basis of that was because the 2009 permit was active and valid, and therefore the applicant was entitled to rely upon that. The same exact analysis and logic applies here. The 2015 SOC predicated on that line was extended and is still valid. And so we contend that we are entitled by law to rely upon that. Now, we know the abutters are saying that the dune goes to the road, and it very well may. And frankly, and to be very blunt about it, the commission may not like this result, but this is the law. The law entitles us to rely upon this line. Now, having said that, in the materials that I've submitted, we have also taken a position that what we lawyers call is in the alternative. So without waiving my argument and without conceding that we need a variance, if the commission decides that the dune goes all the way to the road, we have, under a reservation of rights, asked for a variance to allow the project to go forward. And we have made a case in our written materials, and I'm happy to discuss it in as much detail as you want, that we have met the criteria of your regulations for a variance, and that the commission would be well within its authority to grant that variance. And we would suggest that the commission should grant the variance because we meet the criteria that there's no adverse effect to the environment under your regulations. And moreover, specifically, the regulations allow a variance to be granted if a denial would so restrict the property as to result in what's called a regulatory taking. And we've made that case, and I simply want to say one thing about that. I looked at the current tax assessments, and the property to the left and the right, one is assessed at about 3.5 million. It's all in my letter. The other one's about 2.5 million. However, when you look at the land valuation, each property on the left and the right are assessed identically, $2,210,000 $900. My client's property, after this commission denied the permit project back in 2012, was reduced by the assessor to $24,000. Currently it's at $34,000. So that is an economic loss to my client of $2,167,400, or 98.43% of the value of the property. My suggestion to the commission is that this is a clear case that if a denial will result in a taking, and you have the authority and the power to prevent that from happening and to allow a modest 2-bedroom house with a 2-bedroom septic to be put on this property. So again, in summary, we contend that the law allows us to use the 2009 line, in which case this project is a buffer zone project and meets your performance standards. Alternatively, if you feel the dune goes to the road, we're asking for a variance. We think you can grant it. We think you should grant it.
Mr. Wall, how would we know if the dune did extend to the road without a new delineation?
That's all I have to say.
I just asked a question. I'm not sure if you heard it. I don't understand. You know, how would we know if the dune extends to the road without new delineation?
There is expert evidence that's been provided in the past hearing, and I think Mr. Reed had, that says that there are experts that say that dune goes to the road. And we would concede that the dune does go to the road. We do not concede that we have to abide by that delineation. We believe that we can rely upon the 2009 delineation.
And I guess I have concerns because this is another notice of intent. So in my view, we have a new notice of intent before us, so it would be legitimate for us to ask to have an update on an 11-year-old wetlands delineation.
And again, if you go back in time, Mr. Chairman, there was a new notice of intent before you in 2011, and the DEP said that we were entitled to rely upon the 2009 order of conditions. The fact pattern is exactly the same. You have a new notice of intent before you, but there's a valid, currently existing SOC in effect with the delineation shown on the plan.
Right. I'm going to ask commissioners for any questions or comments at this point. We also have Town Council Amy Kessel here tonight. If Amy, if you have any comments you want to make at any point in time, please go ahead. Let's see. I'm going to start in the order that I see, folks, and that would mean Mark, you're first.
Thank you, Brad. I don't have any questions at this moment, but thank you.
Okay. John?
No questions, no comments.
All right. Stan?
I think you answered all my questions with your comments, Brad.
Okay. Ernie?
Yeah, I don't have any questions at this point in time. Thank you.
Okay. Carolyn?
No, I don't have any questions. I think we're all caught between a rock and a hard place.
All right, Jim?
Yeah, all I would say is just looking at the site, it appears that the dune habitat essentially goes to the road. So it would appear that that 2009 delineation is incorrect. And so I wouldn't mind just seeing a new delineation to see what exactly we are dealing with at this date. And I don't fully understand why that's not relevant to this as a brand new notice of intent before us. So that's my comment.
All right, thanks, Jim. All right. Amy, did you want to offer any thoughts on the question of a wetlands delineation?
I really don't have much of a comment. According to Attorney Wall's letter, there is a valid superseding order of conditions that doesn't expire until December of 2021. So that line would be established. However, this is a filing. It's also under your wetland bylaw, which the DEP obviously, doesn't necessarily control. However, we are looking at a very, very unusual situation where we would have a wetland Protection Act order of conditions with one line, and then we would have a wetland bylaw order of conditions with a separate wetland line for a property, for one property where the coastal dune performance standards under the bylaw are not necessarily much more stringent than the Wetland Protection Act regulations. However, again, the Wetland Protection Act does not have a 50-foot no structures, no build zone.
Thank you, Amy. All right, well, I think I'll ask for comments from other members of the Walsh team. And then if not, if there's no further comments there, then I'd ask for comments from Mr. Reed. All right, no further comments. All right, Mr. Reed, did you have any comments you wanted to make?
Thank you very much, Mr. Chairman. I represent, as I did before, Mr. Charles Curtis of number 6 C Street Extension, which is across the street from this lot. You should have from me, and I hope everybody's had a chance to read my letter of April 2nd, responding to Mr. Wall's submission of March 30th. You should also have a memorandum from Arlene Wilson of A.M. Wilson Associates on behalf of Mr. Curtis, our client, also dated April 2nd, I believe. First of all, I completely disagree with Mr. Wall and with the suggestion that the 2009 delineation remains binding on this commission. As he pointed out moments ago, the 2011 submission of a notice of intent by Walsh Brothers was within the original 3 years of the 2009 delineation. And that's why the state determined that you were bound by it, because you had approved it less than 3 years before. That is the life of a delineation, 3 years. It's not the life of the permit, the life of the approval. It's 3 years from the date of your determination, not from the expiration of the order of conditions. This is, as you said, excuse me, an entirely new notice of intent for a different project, and in this case, exclusively under the bylaw, not under the State Wetlands Protection Act. The fact that they have an outstanding superseding order of conditions from the state under the Wetlands Protection Act does not bind you to the 2009 delineation under the Wetlands Protection Act, for your application under the bylaw. The best case I would suggest for my position is the very case that Mr. Wall cites, the Rochester bituminous case versus the Conservation Commission of Rochester. That was a request to extend an order of conditions, I think a second time, but certainly well beyond the original first 3 year period. And the court concluded, as the regulations say, that the commission or the issuing authority has the authority to extend orders of conditions beyond their original term. In fact, more than once, if they wish to do so. But it also says that in making the determination of whether to extend or not, the commission has it fully within their authority to consider new evidence of whether the delineation and the facts upon which you made the original order remain valid and viable and the same. And if they do not, you have the authority to deny the extension. So since you have the authority to deny an extension of your own order of conditions based upon change of circumstances, you certainly are not bound by your own determination made 3 years before. And I would suggest in this case that having gone beyond the original 3 years from the 2009 delineation, that you are no longer bound by that, certainly not for an entirely new notice of intent for an entirely different project. The fact that the appeal of your denial is still pending is a mixed issue. As I put in my letter, the court actually decided to uphold your denial back in 2007. That denial has not become final, however, as Mr. Wall indicates, but only because they have chosen to pursue the regulatory taking case parallel to the appeal of your decision. Otherwise, that would have become final back in 2017. So it's not for a want of disposition of that decision that this case is still pending. It's because they agreed to a stay of that proceeding while the parties in the Falmouth case on which they relied in bringing their regulatory taking case pursued their own appeals and lost. And I don't know whether it's pronounced Smith or Smythe, but Smythe versus Falmouth was overturned by the appeals court, and they sought further appellate review before the state Supreme Judicial Court, which was denied, and they sought further appeal to the United States Supreme Court, which was denied in December of 2019, I believe. That case is gone. Mr. Wall cites in his memorandum some recent decisions or a recent decision that he thinks changed the process by which he or his client or anybody else could appeal an alleged regulatory taking by going to federal court instead of state. But I would point out that that decision, and I don't know again if it's pronounced Knick or Nick decision, was decided 6 months before the United States Supreme Court declined to accept the Smythe versus Falmouth request for further appeal. So it would appear that it does not make a substantive change in their present claim based upon the same analysis. So I don't think the regulatory taking case has changed at all since it was last before you. And if it has, that should be brought up in the Superior Court where the case is pending against the town of Harwich and against the Board of Health, frankly, but not before you in an effort to get you to change what you decided in 2016 and what you're again being asked to decide today. I would also point out one other item. Mr. Wall brings up the fact that there was a settlement of the Wetlands Protection Act appeal that took place in the administrative appellate process. This application is not consistent with that settlement. That settlement in paragraph 13 specifically says that the applicant is to come back to this commission with a bylaw application only, based only on the plan of record in that appeal. And that is not what they have done tonight. When they did that back in 2016, you denied it. The application before you tonight is on an entirely different plan than was approved in that settlement. And this is not consistent with their own settlement agreement reached with us and with DEP several years ago. So I see no reason for you to change your position. I think you should make a decision consistent with your prior denial of the previous notice of intent. I think you should consider, you should still deny again the variance request if you even reach the merits of that. And I would refer you to Ms. Wilson's letter to you addressing specifically Mr. O'Reilly's claims and analysis where he thinks they meet the variance criteria and we do not. And I would ask you to stick by your position, to require that if this applicant is going to go forward, they must, in order for their application to be complete, submit to you a currently surveyed plan showing where the dune is and to delineate the boundaries of that dune as it presently exists on the ground today, so that you know what you're deciding, so you know what the implications will be of any such decision, or should you reach the merits of the variance request, any such a variance. And I would ask you to stick by that and to make the same decision you did before, and to either deny this application and require that it be submitted completely to you with current and accurate and verified information before you make a decision, and not feel bound or constrained by a previous mistake, which is what it was. Everyone agreed, including all the applicants, experts, and Mr. Wall tonight, that the delineation in 2009 was wrong. It was completely incorrect. And it's not appropriate to compound a mistake after all these years by feeling bound or constrained to abide by what everyone knows was not correct in the first place and which has long since expired. Thank you, Mr. Chairman.
Thank you. Any additional comments from either side or members of the public? Arlene Wilson.
Thank you, Mr. Chair. Just a comment relative to something that Amy Quessel brought up, and that is the issue of having different delineations under a bylaw and 13140 on the same application. It is not all that unusual. It happens in Falmouth, for instance, all the time, where their definition of floodplains is different than states and moves the line further inland. It happens in other communities as well. So it wouldn't be the first time that that happened. Mr. Reed has gone through most of the issues that I brought up in my letter. So one thing that I would like to add is that there's a section in the town bylaw. We all make the mistake of referring to everybody's regulations all the time. We do the same thing with 13140. And we don't look at the actual statutes enough. Section 310-17 of the town law says that the commission shall require applicants to avoid wetland operations wherever feasible. And where it's not feasible, the commission shall require the applicant to provide full mitigation. Regardless of where the delineation line lines up on this plan, whether it's as the applicant has it today or where the line actually should be, which is up near the street, the applicant has not and cannot provide full mitigation for the work they're doing. There simply isn't enough space on the plan, on the lot, that isn't a resource area to provide that mitigation. And since he can't provide that mitigation, then he's not due a variance under your regulations. So I would also urge the commission to adopt the same denial that they did in 2016, because the issues here really are not different than you dealt with before. Thank you.
Thank you. Let's see, any additional comments? Any folks? Well, my preference is to request a continuance for this while the applicant produces a new wetlands delineation. That's something that I'd like to see happen. We can discuss that now. Mr. Wall, is that something that is agreeable from your side?
Well, I guess before I answer the question, Mr. Chairman, I'd like to ask a little bit of feedback. I mean, there's going to be time and money spent on something. Mr. Reed referenced the last time that we were here that there are expert reports the last time a project on this property came before you that both say that the dune goes to the road. So I've conceded for purposes of the variance only that the dune goes to the road. Does the commission need to have an expert tell us that to act on the variance request? In other words, the experts are going to say that the dune goes to the road. So if that happens, then the variance request is before you.
Right. And then, you know, it only could be supported with a variance request for a taking. I mean, everything else in our regulation bylaws would say that there shouldn't be a structure on a dune. Right. So that would be the only evaluation, I think, for the commission to make. But to me, it's a pretty important decision. A lot of time has passed. I don't really think it's appropriate to make a motion and rule on this tonight without that information before us. But that's my preference. We can vote on it, or other folks can chime in on that thought. But it's really, one of the two. We ask for the wetlands delineation, or we go ahead and evaluate the proposal as it stands now. Ernie, did you have a comment?
Yes, I did, Brad. Arlene raised the point also about mitigation. And there's nothing in the proposal that we have before us tonight that indicates how they propose to meet that requirement. So I would ask that they come back to us and let us know what they plan to do with respect to the mitigation requirement that we have in order to grant a variance.
May I ask a follow-up question to that, Mr. Chairman?
Sure.
So, Mr. Crabtree, I just want to make sure I understand. The way I understood Arlene's comment was that your bylaw, your buffer zone regulations require there to be mitigation when there's projects in the buffer zone. And we cannot provide that because there's not enough wind. But in my letter of February 16th, I did address this in full, and I suggested that the commission has authority, if you read the regulations carefully, to allow new construction on a vacant lot with some flexibility on those mitigation requirements. And I also cited a case that you had recently decided that I was involved in. You allowed a house to be constructed, and you had some flexibility on that mitigation requirement. Are you asking about that particular requirement, or are you asking about the reference of mitigation and a variance? Because I just want to know which one I'm dealing with.
I think it's the former. I'm not so concerned about, and again, we've always taken the position that you mentioned a prior case that we've considered that, however, every case that we look at is looked at in its own merits. We don't set precedent by any of the decisions that we make. And I think it behooves us to ask for some sort of a proposal by the applicants for how they would expect to meet the mitigation requirement, if at all, or are you just saying that you're not going to?
Well, I think we were saying that we can't, not that we aren't going to or don't want to. And I do understand your point about every case being decided specifically on the property and not setting precedent. But my reference to that prior case was more about the commission's interpretation of the regulations, which I think you can set precedent on. And basically, on that particular property, it was a vacant lot where any change of the property would result in mitigation, and there was nowhere to put it. And the commission said, well, on new construction, we're going to allow that to happen. And that's the kind of a parallel I'm trying to make with this one. But yeah. I want to point clear to you, Mr. Commissioner Crabtree, and to all of the commissioners. Whatever is decided here, obviously there's going to be appeals. The applicant, if denied, will validly appeal. And based on past practice, I think the abutters will too. So what we want to do is make sure that whatever the decision that is made on the merits. And so I don't want to be denied if there's a need for information that is something the commission believes it needs. I would like to know that so that we don't get denied on a lack of information and just come back and waste everyone's time. I want to get to the merits of this one.
Ms. Wilson.
I just wanted to correct something that Mr. Wall has said. The section that I quoted is from the bylaw, not from the regulations. It doesn't refer to work in the 50-foot buffer. It refers to alterations that impact wetlands resources. And this project, being in a wetland resource, requires mitigation under the bylaw, quite apart from whatever mitigation may be required under your regulations.
Thank you. Carolyn?
If we are to go forward any which way on this, I'm not sure I see the need for a new dune delineation if the Walshes are willing to come up with some sort of an official document, legal document that recognizes the dune goes to the street.
Mr. Chairman, if I may.
Yes, please.
I have the same concern that Ms. O'Leary has, is that how do you establish a wetland line to say it just goes to the street? I mean, there have been wetland lines that have been agreed upon, but there's actually a delineation. So, you know, what would the delineation here be? Would it just be to the street? Does it cover the street? Does it, I mean, I'm not really sure how we go about determining where the wetland line is just by saying it goes to the street. I don't know if Mr. Wall has any ideas or Mr. Reed. I don't know if either have an idea.
Well, I'm not a wetland scientist, but when I said it goes to the street, it's because the street is pavement. So I'm not sure, and I say this without any kind of intent to be patronizing or anything, but the sand stops at the road. So I don't know if we need a scientist to say that.
Okay. Okay.
Mr. Reed?
Mr. Chairman, I believe I appended to my first letter to you a couple of months or so ago a copy of Stan Humphrey's letter when he was representing Walsh Brothers in the earlier matter, where he agreed that the entire property was doomed right out to the pavement. If that's sufficient for your record, then I think we have that. I also have to share, I think, Mr. Wall's concern, and that is that if he is willing to concede for purposes of your review that the building that is proposed is within the dune, within the resource area, not within the buffer, and if he's willing to concede that they do not have the ability to propose the required mitigation because there is no upland that can be altered in order to compensate for the construction of the dune, then I think in fairness, he ought not be sent out to come back with more expensive information, which you already know to be true. And if you are able to make a decision based upon those concessions and based upon information already in your record, then I think in fairness, you should do so. If, however, you feel that you need to see that in black and white and not based upon either concessions or past determinations, then I would also agree with Mr. Wall that you should not make the decision based upon lack of information rather than on the merits. But in fairness, he should not be sent out to gather information, which you already know to be true, just to come back and have you tell him that it's not sufficient to justify the relief that he's asked for. If you're going to deny it, I think you need to deny it on the merits, and I certainly hope you will, whether you base it on the information you already have or any additional information you may ask of him. But either way, I think you should make clear what your intentions are to the extent that you know right now that this is not an approvable request.
I appreciate that. I think that it's a complex notice of intent. I think many of our commission members were not here previously. And so I have concerns about ruling on this at the first hearing without a document. You know, we have the Humphreys letter from years ago, but we don't have a contemporary wetlands delineation that says, yes, in fact, the dune, this would be a structure in the dune. So that's my concern as to ruling tonight. So I think I still favor having another delineation, but you know, I'd like to hear from other commissioners. It's really one or the other. We're going to rule on this project tonight, or we're going to ask for that piece of information in the near future. Any comments or preferences from the commissioners?
Yeah,
Brad.
Jim, then Ernie.
Sure. So I just think we could make a more accurate ruling if we had that delineation. I mean, it does, I would agree. It seems like everybody agrees it appears to be entirely dune, the property. However, if we're looking to rule on that, it'd be nice to have that actual delineation to reference in our ruling. So I would prefer to see a delineation, whether it's done through a third party by the town or by the applicant.
Thank you, Jim. Ernie?
Yes, thank you. Yeah, I agree with Jim. I do think we need to have a formal delineation done. I still would like to see something from the applicants confirming that they have no intent and that it's basically impossible for them to do any mitigation on the site. Because I think we need to have all of the facts before us in writing so that we can look at them in total and make a decision based on all of the information, not just representations that are being made to us verbally right now. I don't think that's adequate from my perspective.
All right, John.
Yes, I agree with Ernie and Jim. I think particularly in that in various places in the various filings, it has been noted that the wetland area changes over time. And I think that's part of what's underlying your need to see this, Brad, is that we don't, I mean, it would be nice to rely on a concession that's over 10 years old that the whole thing is dune, but that could always be challenged on the basis that it's changed since then. So I think that we do need a contemporary delineation to base any decision we make on.
All right, thank you all. Is that acceptable, Mr. Wall, to have request a delineation and have a continuance to a later meeting?
Well, I'll go back at it one more time. If I can pick up on what Mr. Reed said, I know we're on opposite sides, but I think he and I are seeing this the same way. I am willing on behalf of my client, for purposes of the variance only, to concede that the dune goes to the road, but reserving all of our rights to claim that we're entitled to proceed under that extended 2015 SOC. But again, I've heard 3 commissioners tell me they want to see a delineation. The last thing I want, after all the resources that have been put into this project, is to have a denial on lack of information and get denied, and then have to go get the delineation and then refile and come back here in a month or 2. So maybe if I could ask for kind of a show of hands or a straw vote on that one issue, not the everything, but just do we need this delineation or not?
Well, I will say that you've heard from myself, Jim, John, and Ernie. And so you have heard from a majority thus far that would like to see a wetlands delineation. I'd also like the commissioners to have a chance to really review this, because without a delineation, we're just considering the taking issue in a variance under a taking. And I feel that's a heavy load for us to consider at the first hearing. And so, I would like to request that. If any other commissioners want to speak up about the wetlands delineation, go ahead right now. I think this is it's a very complex project for us to consider, with 45 minutes on the first hearing and expect we're going to rule on it. Mark?
Yes, Brad, I would agree that I think the new delineation is absolutely appropriate in fairness to everybody concerned.
Thank you, Mark.
I'm in agreement as well. I mean, this is the same we would require of any other project. We want to have the specific current information, not based on hearsay or whatever, or other things that are much older. Things have changed in the time frame that it was last delineated. So I agree as well.
So, Mr. Chairman, I can definitely see the way this is going. So if we're going to continue, we will ask for a continuance to supply some new information about the dune. And I say new information because I'm not sure we need a formal delineation or whether we can get a letter from Stan Humphreys that says he revisited the site and he confirms the dune goes to the road. But I will ask for a continuance for more information, to gather more information on that issue. And also I heard Mr. Crabtree's comments regarding the mitigation, which we will also respond to. Is there anything else the commission feels that it needs, so that I have a complete list? We can get a continuance and then we can come back for a hopefully third and final hearing.
Yeah, this isn't really on you. I think it's just that I would like to see our commissioners have a chance to evaluate these issues, particularly in terms of the variance. And so I think it would be to our benefit to have that extra time to review that. So that's the third issue, is to have the commissioners, dig into this fairly large packet and try to understand that issue. So I think it's the mitigation, it's the variance, and it's the wetlands delineation. Those are the three topics that we need to spend some more time on.
And Mr. Chairman, I didn't mean to leave that out. I did hear you on that. I was simply asking for more information, but I do agree with you. I would urge the commission to look at the letter that I wrote. And if you need any more information about the variance request, this is a very, very weighty decision, because if my client is granted a permit, it's something they've been seeking for a decade now, and they will be very happy to have that permit. And I did speak with Attorney Quessel earlier. I do not say that this is not meant to be a threat or bullying or anything. This is a statement of fact that if it is denied, my client will pursue this, because it's a $2 million+ property at stake. And if the commission ultimately reaches a decision to deny it, my client does intend to go to court and unfortunately sue the town for compensation. So I would urge you to read the letter, think about it, look at the information that's been supplied, because it's very, very good.
All right, thank you very much. Mr. Reed?
Yes, Mr. Chairman, thank you. Before voting on the extension, I believe, if memory serves me, your conservation agent in her initial evaluation and comments to the commission, and I believe Ms. Wilson in her report as well, also expressed concern for whether or not the survey information on the plan was up to date, because it was, I believe it relied upon the old plan and questioned not only whether the edge of the dune had changed, but whether other features within the property had also changed since that original plan. So I think as part of the delineation, it may be appropriate for Mr. O'Reilly to update his plan as well as part of that.
Through the chair, this is John O'Reilly.
Yes, please.
Thank you. We did use the survey that was done most recently in 2015, I believe. We've done a site inspection. We did not find the site change significantly on the contours that are shown on the property. I'd be happy to revisit that again and just verify that, but we feel comfortable with the plan that we've submitted. Thank you.
Okay. I mean, we have the option of asking for, our conservation funds to pay for delineation as well, but I can't make that decision tonight. So I think we should ask the applicant to do that, to update the 2009 delineation. When would you like to continue until, Mr. Wall?
I'm sorry, Mr. Chairman, your screen froze, so I didn't quite hear what you said about you. You said that you had the right to ask for the conservation to do it, and you kind of went out on me.
Yeah, sorry about that. So, sometimes we will ask, or we'll do our own evaluation on these things with Conservation Department funds. I really can't make a decision on that tonight. Our agent's out. So I think we'll just request that you update the 2009 delineation, and then I'll ask, when would you like to continue until?
Hey, Brad, if I may, I think we've done that in the past where we questioned the delineation that was being given. So in this case, we're asking for an updated one. So I think if we had some question on that one, that's where we might put funds on from our end.
Okay.
So, Mr. Chairman, we're going to need a few weeks because I have to contact our coastal geologist. Could we have a meeting in early to mid-May? Are you meeting on the 5th or the 12th?
Is the 5th a Wednesday?
It is.
Yeah, so we could continue until May 5th if you want.
Could we have till May 5th? Mr. O'Reilly, do you believe that's enough time for us to do what we need to do?
Yeah, we should be able to pull together the information they've asked for.
Okay.
Assuming fans available.
Okay.
All right, thank you. Any last comments on this? All right, no comments from members of the audience. All right, hearing none, I'm going to move that we continue this hearing for 5C Street, map 7, parcel D28 until May 5th, 2021.
I'll second.
All right, seconded by Carolyn. We'll have a roll call vote. All those in favor say aye. Those opposed say nay. Starting with Mark.
Aye.
John.
Aye.
Stan.
Aye.
Ernie.
Aye.
Carolyn.
Aye.
Jim.
Aye.
Myself, Brad Chase, aye. So the motion carries 7-0. All right, thank you all. We'll see you on May 5th.
Thank you, Mr. Chairman. Thank you, members of the commission. I know this is a tough one. We appreciate your time and listening to us.
Thank you. Good night.
Good night. Okay, next on the agenda, we have a series of proposals for 19 Wachusett, and they're all going to be either withdrawn or continued. So I'm going to go through this fairly quickly and make those appropriate motions. And I don't expect to have any discussion on this tonight because we're going to hear these soon. So the first is a request to amend an order of condition for 19 Wachusett Road, map 5, parcel K1-41. It's a request to amend the order of conditions SE 32-2360A. Was a request to change a patio into a sunroom, install a roof over another portion of the patio, and install solar panels on the roof. The applicant has requested a continuance until April 21st, 2021, and I move that we grant that continuance. Can I have a second?
Second.
All right, seconded by John. All those in favor say aye, starting with Mark.
Aye.
John.
Aye.
Stan.
Aye.
Ernie.
Aye.
Carolyn.
Aye.
Jim.
Aye.
Myself, Brad Chase, aye. So the motion carries 7-0. Okay, next, we have a request for determination of applicability for 19 Wachusett Road, map 5, parcel K1-41, proposal for a covered porch. They have asked to withdraw this at this point. I'm not even certain if we have to make a motion on that. I think it's a withdrawal. And so I think we're good to go. Anyone have thoughts on that?
I've got a question. Being that the work is clearly in progress, how do we deal with that? I don't quite understand.
Well, there was a work stop order at the last hearing for the covered porch, so the work should be ceased. I did reach out to our agent, and I wasn't able to get an answer before Amy had to go, for some medical treatments. So as far as the commission knows, there's a work stop order for that work at that location.
I drove by there today, and it does not appear to me that that work stoppage is being recognized. I may be incorrect, but that is not what I saw.
All right, thanks, Mark. Well, I think what we can do is, document these observations. They're coming back on the 21st, April 21st, so we'll have some discussion with the applicant then. I don't think we can do much tonight on that, otherwise than make the minutes reflect that you had that observation. We were there yesterday, and there wasn't any specific work occurring on the porch yesterday, but it was a pretty active construction site, all the same. So, but I think, we just need to go ahead and make these motions, and then we'll address all these things when we come back on the 21st. So I'm going to, for the next request for determination of applicability, 19 Wacquasit Road, map 5, parcel K1-41, proposed shed. The applicant has asked for continuance until April 21st, 2021, and I move that we grant that continuance. Could I have a second, please?
Second.
All right, seconded by Mark.
Excuse me, for clarification, I thought you just said that for the shed, he's withdrawing it. You just.
No, that was for the covered porch. That's for the, that's the north side covered porch that he's withdrawn.
Because it's in the notice of intent that we were originally, the revised notice of intent that was being questioned and voted on, and that's been continued.
Yes, that's the southern patio that the work is being, where a work stop order was placed on that southern patio. The northern patio has been withdrawn. And so.
What was your first motion then, Brad? I thought that was your first motion.
No, that was the amendment of the order of condition, that we accepted the continuance for that's to change the patio into a sunroom.
Okay, all right.
That's the amended. So that's continued. Work on that northern patio apparently has been withdrawn. This came in today. And then we have a motion to accept the continuance on the shed. Mark has seconded that. Any further discussion on that? All right, then all those in favor to continue the shed RDA until April 21st, 2021. Those in favor say aye, starting with Mark.
Aye.
John.
Aye.
Stan.
Aye.
Ernie.
Aye.
Carolyn.
Aye.
Jim.
Aye.
Myself, Brad Chase, aye. The motion carries 7-0. Next, we have a request for determination of applicability for 19 Wacquasit Road, map 5, parcel K1-41. This is for a 4-season room. This one has been withdrawn. So that came in today, so we simply recognize that it's been withdrawn. Next, we have 19 Wacquasit Road, map 5, parcel K1-41. This is for the pool fence, and they've asked to continue this until April 21st, 2021. And I make a motion that we grant that continuance.
Second.
All right, seconded by John. Any discussion? This is all quite unusual to have so many RDAs for work on the same property.
I have a question. I think Amy thought in her notes from the past meeting, the March 17 meeting, that this should be an NOI and not an RDA.
Yeah, she did make that comment, and so we'll discuss that on April 21st. But the applicant has submitted this as multiple RDAs.
Okay.
And so that kind of makes it complex. To me, it seems like it should have been a single NOI, but we can discuss that on the 21st.
Okay, thank you.
All right, so we've got a motion on the table, continuing the pool fence RDA until April 21st. All those in favor say aye, starting with Mark.
Aye.
John.
Aye.
Stan.
Aye.
Ernie.
Aye.
Carolyn.
Aye.
Jim.
Aye.
And myself, Brad Chase, aye. So that motion carries 7-0. All right, that concludes 19 Wacquasit Road for tonight. Next, we have an RDA for 11 Woodbine Road, map 12, parcel X1-31, proposal for a change in foundation. Is there an applicant here tonight to represent the project? Yep, go ahead, please.
We're simply applying for a determination regarding some foundation repairs to stabilize the current foundation in place. And I guess I would open it up to any questions regarding the scope of work.
All right, thank you. All right, so we've reviewed the proposal. We've received comments from our agent. So I'm going to open up to comments and questions from the commissioners, starting with Mark.
I have no questions or comments. Thank you.
All right, thanks. John?
Yeah, I don't have any comments or questions either.
Stan?
No, I'm all set.
Okay, Carolyn?
I'm all set.
I skipped you, Ernie, you're up.
No, I have no comments on it, Brad. I wonder if we want to read Amy's comments into the record, just so we'll have them on the tape.
I don't really feel the need to do that. I think we've got a really big agenda, so I think that we can refer to those comments if we need to for the public record.
That's fine.
So, yeah. Okay, so I have no comments either. It's an RDA, we can condition it. I think that, Amy supported the proposal as it was. So I'll ask one of the commissioners to make a motion on this now.
I'll make a motion to approve the foundation work at 11 Woodbine Avenue with a -2 determination.
Have a second, please. All right.
Same.
Okay, seconded by Stan. All those in favor say aye. Those opposed say nay. Starting with Mark.
Aye.
John.
Aye.
Stan.
Aye.
Ernie.
Aye.
Carolyn.
Aye.
Jim.
Aye.
And myself, Brad Chase, aye. So the motion carries 7-0. You're all set. Thank you very much.
All right, thank you very much to the commission. Appreciate your time.
Okay. All right, next we have an RDA for 20 Bishop's Lane, map 40, parcel N5, proposal for a pool deck and portion of a walkway. Do we have a representative here to present the project?
Yes, sir. Robin Wilcox from Sweetser Engineering. Mr. Nicholas was in front of the board within the past year from John McElway, where you had agreed on the location of the BVW as well as the 50 and 100. This is same plan. However, he would like to install a swimming pool inside of a deck, and there's a little bit of walkway that he wants to put in. Comes to around 840 square feet. We've done mitigation to the tune of almost 1,800 square feet, more than 2 to 1. It's essentially a privet hedge around the outside for a little bit of privacy in that area, as well as plantings of junipers in the corners in order to keep people out of the 50-foot, which happens to encroach in the northeast corner.
All right, thank you. So our plans don't really reflect the mitigation. Did you have a discussion with Amy before she left?
We had sent in a modified plan, and I apologize. It was dated the 6th, and we had a computer glitch, and so it didn't go in until today.
Okay. The modified plan is on Dropbox.
And the modified plan has a revision date of 4/6 of 2021.
All right. Well, let's see if we have any questions or comments from the commissioners, starting with Mark.
I'm going to abstain. Thank you.
All right. John.
Yeah, so First, I think there's a problem with the mitigation because privet is mildly invasive and it should not, I would not agree to planting privet anywhere within the 100-foot buffer as mitigation. I think there needs to be something native. I'm not sure what to suggest. I would be happy if we agreed otherwise to defer the specifics of the planting to Amy, given when Amy becomes available to consider such things, but I wouldn't agree to privet. Also, I visited the site and I was struck by the amount of invasives are on the back of the lot, and I'm not sure where the lot line is relative to the open space there, but there's very well established bittersweet, among other things. I mean, big, heavy bittersweet vines, and I would request that along with any mitigation that the bittersweet back there be taken care of. I'm not sure what to say about the open space, which is common space, which belongs to the neighborhood association apparently, but something should be done about that. I guess I don't have anything further to say in particular about the specifics of the hardscape and construction that is being proposed here.
All right, thanks, John. Yes, response, please.
Yes, most of the invasive is in the 0 to 50. There is a concrete bound in both the northeast and the northwest corner, and you can stand on them and sight all the way through. It's the limit of the clearing is actually out into the open space at this point. That was part of the reason for the privet, was to stop people from going into the open space and into the 50-foot buffer.
How do you respond to Mr. Ketchum's comments on the privet just would not be an acceptable plant in the buffer zone? Do you have alternatives in mind, or you want to think about it?
I can work on it. If we do, I would need to either fortunately or unfortunately push it for a month, only because I will be in the extreme south of the United States next meeting.
Okay. All right, let's continue on. Stan, any comments?
Yeah, I'm just looking back to what Amy's comments like. On the plan, I don't see the square footage of the proposed structure within the 150 to 100. And therefore, how do you determine the mitigation required? I know you said 1,800 square feet, I think you had, but I'm not sure what the structure square footage is.
The slope is 28, which is 784 square feet. The walkway is 3 feet by 18 feet, which is 54 square feet.
I don't want to be doing that now. Usually the plan would include it right on there and with a summary of that. So I would suggest that be included on the plan.
Stan?
It is included on the plan, man.
Where is it?
The revised plan on Dropbox has it.
Oh, well, that just came in. I didn't see that. Okay.
Anything else, Stan?
No.
Okay, Ernie.
Yeah, when we were out at the site today, there were 2 trees that are within the staked area on the lawn. Are you proposing to remove those 2 trees? One of which is a very large and mature tree.
Yeah, that's the large oak. Unfortunately, it is in the way. The other oak that also would be coming down is looks somewhat diseased and a little mangy.
Yeah, I agree with that. On the smaller one, the larger one, I would like to see if there's any way you could keep that.
the good news is it's far away from the pool. If I can talk to Mr. Nicholas about making his deck circular or around where the base of the tree is in order to leave it there.
Okay, that'd be great. Thank you. That's all I have.
All right, Carolyn.
No, I have no comments.
All right, Jim.
Yeah, my only comment for right now is to reinforce what John was saying about the using privet as mitigation. Any mitigation planting should certainly be native species and not invasives. But no other comments at the moment.
All right. So I think we're going to have to ask you to come back. If you can, work that out with the conservation agent as to what the species might be to substitute for the privet, and then address the tree removal that Ernie brought up.
Brad, one other sorry.
Go ahead. Go ahead, Ernie.
One other comment before we let him go. Does this, you're putting in a pool, and I see it's enclosed by a deck, but is it an in-ground pool? Does it require a fence somewhere on the property to wall off the pool?
It does not need a fence. In this case, the Commonwealth allowed the, if the pool now has a cover over it that's automatic, it's not necessary to fence the property, and that's what this is intended to be. The only fencing that we show is the work limit fencing.
Yes, I saw that. All right, thank you.
One comment, I'm surprised John didn't mention it. I assume that this will also include our orders of conditions will also include no fertilizers, pesticides, etc.
This is an RDA, so there's no order conditions.
Oh, good point. Sorry.
Okay, so is May 5th a good time for you to come back?
I'll be nice and tan by then.
Okay, well, we'll all be envious. So I move that we continue the hearing for 20 Bishop Lane, map 40, parcel N5, until May 5th, 2021. Could I have a second?
I'll second it.
All right, seconded by Stan. All those in favor say aye, starting with Mark.
Abstain.
Okay. John.
Aye.
Stan.
Aye.
Ernie.
Aye.
Carolyn.
Aye.
Jim.
Aye.
And myself, Brad Chase, aye. So the motion carries 6-0 to 1. And we'll see you on the 5th, and enjoy your time down south.
Thank you very much. Have a nice evening.
Okay. All right, next on the agenda, we have administrative review plan change request for 32 Dunes Road, map 5-W1, parcel 52, proposed driveway material change. Do we have an applicant here tonight?
Yes, Stacy Kanega from Coastal Engineering Company, here representing the owner and applicant, Thomas and Caroline Lucy, for the subject property. I'd be happy to go over any portion of the original proposal or pre-construction conditions of the site, but plan to focus just on a couple of these changes that were requested. If you've had a chance to visit the site, it is currently under construction. And it is of note to revisit the wetland resource area that the coastal bank is located northwest of the project area, and that an existing impervious driveway and the dwelling itself lie between the coastal bank wetland resource and the project where we originally received approval and where we're discussing tonight. I think in the spirit of time, I'm going to kind of skip my summary, and again, I can go over any piece you want to. I think the overarching, I had included an SKC1, basically to demonstrate that compared to what was approved, the layout really has not changed significantly compared to what was approved before, so we're not proposing big footprint changes. I didn't specifically point it out, but there is listed on the plan that the lawn area within the 100-foot buffer zone has still been reduced, and that's in a comparable reduction to the previously approved plan as well. And then overall, we feel like, you know, due to the nature of where the proposed improvements are relative to the coastal resource area, we really will not be negatively impacting it. And would really just open this up to any questions or further comments I can address.
All right, thank you. I think a number of us made it to the site, and I'll ask if the commissioners have any questions or comments, starting with Mark.
All set, thank you.
Okay, John.
Yeah, so just one question. The letter calls out 3 changes. Those are the only changes that are being proposed.
Correct.
Thank you.
All right, thanks, John. Stan?
No comment.
Ernie?
Nope, no comments. We looked at the site today or yesterday and it looks fine. Thanks.
All right, Carolyn?
No comments.
Jim?
No comment.
Okay. Well, if there's not any comments from members of the audience, I'll ask for a motion from the commissioners. And again, Amy's looking for our approval to handle this through administrative review.
I'll make a motion to allow Amy to handle the request from Mr. and Mrs. Lucy at 32 Dunes Road to change the driveway material.
Can I have a second, please?
I'll second.
All right, seconded by Stan. Any further discussion? All right, seeing none, we'll vote by roll call. Those in favor say aye, those opposed say nay. Starting with Mark.
Aye.
John.
Aye.
Stan.
Aye.
Ernie.
Aye.
Carolyn.
Aye.
Jim.
Aye.
Myself, Brad Chase, aye. So the motion carries 7-0. Thank you.
Thank you. Have a good evening.
Same to you. Okay. So next on the agenda, we have a request for holding a conservation restriction from the Harwich Conservation Trust. They request that the Conservation Commission hold a restriction on a 6.65 acre piece of conservation land located at 0 Deacons Folly Road. I saw Mike Locke earlier. There he is. Hi, Mike.
Hi, Brad. Hi, members of the Conservation Commission. Thank you for the opportunity to present this project this evening. Just for the record, I'm Michael Locke, Executive Director of the nonprofit Harwich Conservation Trust. The 6.65 acres, which is the subject of the conservation restriction this evening, I'd like to just summarize some of the environmental values associated with the land. The 6.65 wooded acres, 100% within the watershed of Sand Pond and the watershed of Herring River. Protecting the land helps protect the water quality of both those water resources. Protecting the land helps protect the conservation integrity of the adjacent Sand Pond Conservation Area, roughly 75 acres, comprised of both HCT, protected land, and town conservation lands under your jurisdiction. And it helps protect the scenic views from the area's walking trails. So the conservation restriction for your consideration of approval this evening has been reviewed and approved by Town Council, the Board of Selectmen, and the trustees of Harwich Conservation Trust. With your approval of this conservation restriction, this project represents another important conservation partnership opportunity with you, the Conservation Commission, holding the conservation restriction. It helps Harwich Conservation Trust satisfy a state grant requirement, which in turn helps to fund the preservation of this land. So I'm glad to answer any questions, and thank you for your consideration this evening.
Thank you, Mike. All right, we'll go through the commissioners to see if they have any comments. I'll start with Mark.
No, thank you.
All right, John.
Yeah, I'd just like to say I'm really happy to see this happening and that all that conservation land north and west of Sand Pond to be filled in. I think it's a great thing. Thank you.
Stan?
No comments.
Ernie?
Yeah, as you know, we live relatively close to this parcel, and I often hear gunshots coming from that location. I don't see anything in here that covers hunting or anything of that nature. Is that allowed on this property, Mike?
Harwich Conservation Trust doesn't allow hunting on the properties that it owns. And the ownership of this property will be by Harwich Conservation Trust, but the conservation restriction held by the Conservation Commission.
All right. So how would you control that sort of thing?
This is the first time I've heard of that possible activity in that area. And so when we do receive reports, we would talk to the police department, bring that to their attention, have them investigate.
Okay. I mean, by the time that whole process works itself out, they're gone, essentially, right? Unfortunately.
It's a difficult situation. In that area, according to state hunting regulations, you're not supposed to discharge a firearm within 500 feet of an occupied dwelling or those traveled roads in that area. Certainly there's plenty of neighborhoods, plenty of houses. I would think the nearest area of town conservation land would be perhaps up in the northwest part of the town. Otherwise, if you do hear continued activity like that in that Sand Pond area, I encourage you to call the local police department.
Okay. All right. That's the only comment I had. Thank you.
Carolyn?
No comments. I echo John's comments. Thank you.
Jim?
Well, I'm happy to approve the conservation restriction and good job getting that property purchased. Thank you.
All right, I agree. Thank you very much for all your work on this parcel. All right, would someone like to make a motion on this item?
I'll make a motion to approve the conservation restriction on, what is the address? On
0 Deacon's Folly Road.
0 Deacon's Folly. Thank you.
I'll second.
All right, seconded by Carolyn. All those in favor say aye, starting with Mark.
Aye.
John?
Aye.
Stan?
Aye.
Ernie?
Aye.
Carolyn?
Aye.
Jim?
Aye.
And myself, Brad Chase, aye. Motion carries 7-0. Thank you very much, Mark. Mike, appreciate your time and all your effort on this.
Thank you all for partnering on another important conservation project.
Okay, that brings us to the notice of intent portion of our agenda. And the first one is 2121 Head of the Bay Road, map 108, parcel K2, and it's vegetation management on the property. We have a representative here tonight to represent the project.
Yes, Lynn Hamlin. I can't video myself, but can you hear me?
Yes.
Okay, then that's good enough. I'm not going to slow you down at all. We were just waiting for the DEP number, which of course was issued the morning after your last hearing.
Mm-hmm. Okay. We did go over this at the last hearing, so there is no new information other than that there is in fact a DEP number. And Lynn, there's been no changes to the plan?
No, we did nothing, just waiting for the number.
Okay. All right, well, we'll run through comments and questions. Maybe I'll shift things around and start with Jim.
No comments here.
All right, Carolyn.
No comments.
Ernie,
No comments. Thanks.
Stan,
No comment.
John,
No comments.
and Mark.
No remarks, thank you.
Okay. Any comments from members of the audience? All right, seeing none, would one of the commissioners like to make a motion?
I'll make a motion to approve the notice of intent for 2121 Head of the Bay Road for vegetation management.
Could I have a second, please?
I'll second.
All right, seconded by John. All those in favor say aye by roll call. Those opposed say nay, starting with Jim.
Aye.
Carolyn.
Aye.
Ernie.
Aye.
Stan.
Aye.
John.
Aye.
Mark.
Aye.
And myself, Brad Chase, aye. Motion carries 7-0. Thank you very much.
Thank you very much.
Okay, next on the agenda, we have a notice of intent for 35 Strandway, map 1, parcel J1-32, proposal for a new terrace. Do we have a representative here tonight for the project?
Yes, we do. Shannon Gumholm, Second Nature Garden Works.
All right, thank you. Go ahead, please.
Since our first meeting with you, which was on March 3rd, we were seeking permission for a terrace, part of which falls into the 50-foot buffer zone. Then we've made some changes that we believe are far less disruptive. First, we removed all of the proposed stepping stones that were in the 50 to 100 foot zone, and also all of the stepping stones that were in the 50-foot zone. We changed the mitigation plantings to match what Amy had requested. We are still going to remove an existing brick walk that is currently in the 50-foot zone. And by making these changes, and specifically by removing the stepping stones in the 50-foot zone, it turns out that the square footage of the existing brick walk that we are going to remove actually has more square footage than the square footage of the portion of the terrace for which we seek permission. Further, we've chosen to mitigate more than is required for the portion of the terrace for which we seek permission that is in the 50 to the 100-foot buffer zone. I believe you all have a plan that has the numbers on it. Or would you like me to read the square footage?
No, I think we have the plan. So there has been no changes since the last hearing. And the brick is, yep. The brick is in addition to the 3-to-1 mitigation. Okay. Well, let's see if you have any comments or questions from the commissioners, starting with Jim.
No comments here.
All right, Carolyn.
I'm a little confused. Must be my hearing or your audio. But you plan to remove the brick walk and you're counting that as a decrease in hardscape?
Yes.
Okay.
I was told that we could do that from the get-go.
Okay. Would you consider leaving that brick walk and putting in more mitigation plantings?
The client doesn't want the brick walk.
Oh. That answers it, I suppose. Thank you.
And Carolyn, that's the brick walk square footage would be in addition to the 3-to-1 that's being mitigated with the plantings. Right, Ernie.
Yeah, I'm just looking at the calculations again. So the area to be disturbed within the 50-foot zone, you're adding a terrace and proposed stairs equaling 86.32 square feet. I mean, I don't know how we generally calculate these things, but sometimes my mind sort of gets wrapped up in the figures. I mean, taking out the brick walkway, if we look at the 86.32 times 3, then the actual mitigation should be about 258 square feet, 259 square feet. So you're taking out the 88 square feet as part of that mitigation, which in my mind still leaves us about 190 square feet of mitigation that's lacking. I think taking out the walkway and saying we're offsetting that against the proposed hardscape that we're adding in, I mean, it all depends on how you look at the calculations. I prefer to look at it from the perspective that we would need additional mitigation on this, as opposed to just saying that you're taking out a brick walkway, which is somewhat pervious, and you're putting in a concrete patio, which is not pervious at all, and it's a wash. So I guess I'm not necessarily that comfortable with using the brick walkway to offset 100% of the terrace and stairs that are being put in. I'd like to see some additional plantings. That's all.
Can I say that the area between the 50 and 100-foot zone, we only had to multiply that by 2, but we chose to multiply that by 3. So we already are over mitigating what we were required to do.
That's a good point. I appreciate that. Yeah, because that provides the extra 162 square feet plus the 88 gets us just about to where we would be for that 259 that I'd be looking for. A little bit shy of that, but it's close.
We can up that a little bit if you need to.
All right, Stan.
I don't have any additional comments.
All right, John.
Nothing from me.
Okay. All right, so in response to Ernie's comments, did you say you could do something additional with the mitigation? Is that what I heard?
Yeah, how much more is he looking for?
What was your
not a lot. Yeah, I'm thinking maybe another 50 square feet or something like that.
We can probably pick that up.
Okay.
What's the, what do you want me to base that on?
Yeah, you'll have to elaborate. I'm not sure what you're asking.
You just said about 50 square feet. Is that just a number you're looking for? Or is that based on a particular calculation that you want us to base that on?
Well, you have 259 square feet with a 3-to-1 mitigation in the 0 to 50, correct? And you're taking off 88 square feet for removing the walkway, which leaves 170. And actually, you're putting in an extra 163 square feet in the mitigation that you've calculated for the 0 or the 50 to 100. So you're pretty much there. I mean, now I'm down to 8 or 9 square feet, which is probably not worth it. So, yeah, I mean, if you don't think it's practical, then that's fine.
Okay. Have we discussed the abiding by the no chemical application regulations we have for the lawn? Has that been considered? That would be part of the order of condition. Is that acceptable to you?
Are you asking me that, sir?
Yes.
Yeah, I'm aware of that. Andy informed me.
Okay, so that would be one of the orders. Okay. Myself, I'm not really in favor of new concrete introduced into the 050. I understand the mitigation meets our regulations, so that's satisfactory, but I'm still not in favor of encroaching and having new structures put in the 050 in this case, even with the mitigation. Any additional comments from members of the audience? All right, would one of the members like to make a motion, please?
I'll move to approve the order of condition, to approve the NOI for 35 Strand Way.
Have a second, please?
I'll second.
All right, seconded by Ernie. All those in favor by roll call, say aye. Those opposed, say nay. Starting with Jim.
Nay.
Carolyn.
Aye.
Ernie.
Aye.
Stan.
Aye.
John.
Aye.
Did we lose Mark? Are you still on here? Mark Coleman?
I just got back, Brad. I missed most of it. I'm sorry. My signal failed.
Yep. We've got a motion on 35 Strandway. It's that proposed terrace with mitigation. Do you want to vote or?
I'll skip the vote. I missed most of the discussion. I'm sorry.
Okay. All right. And then myself, Brad Chase, nay. So the motion carries, let's see. Don, Stan.
420.
420. Yeah, 421, the motion carries.
421.
Yeah, 421. All right. Thank you very much.
Thank you.
Okay, next on the agenda, we have a notice of intent for 4 Braddock Street, map 7, parcel F17. It's for beach maintenance. Do we have a representative here tonight?
Here, Greg Winston, Dave Plunkett.
How are you?
Pretty good, how are you?
All right, if you want to describe the plan briefly.
Yes, actually, it's pretty simple. This is we have been going for about 35 years or more. It's been maintained.
I'm sorry, this is breaking up. I can't hear him.
I'm sorry?
It was a little bit rough. Just now it sounded clear. Do you want to try again?
I'll try again. How am I doing now?
That sounds good.
Okay. Okay, this is a property that Dave and myself have owned for about 35 years. It was originally part of the old Melrose Inn, running as the Winstead Inn and Beach Resort for over 30 years.
Just a comment, when you look away from the computer, we lose your voice.
That's what's happening.
Right. Then I won't look away.
Okay.
Okay, Brad, nice to see you, by the way. So basically all we're doing is we're just asking for a continuation of what we've had for years. Basically what happens is Todd, years ago, of course, we've lost Todd now, but his son Skipper has been doing it ever since. Basically, all we do is we just we try to keep the sand on the beach, and we've got what we call beach fences, which most people refer to as snow fences, and they're typical beach fences, cedar fences, to hold the sand on the beach. But due to the southwest prevailing wind, we lose a lot of sand off the middle of the beach. So we want to, every year we have to sort of pull it back out of the dune. We don't disturb any of the beach grass. So we don't disturb any of the any mitigation as far as anything growing. We're just pulling the sand back into the hollow, and it's something we've done every year for all the years we've owned the property.
The renewal of a previous permit we already had, and we had the TP number. We got the day after your last meeting, so we were unable to go ahead and Amy got it the next day.
Okay. Thank you. So let's have questions and comments from the commissioner, starting with Jim.
No comments from me.
Carolyn?
I was reading Amy's notes and she had a couple of questions. When you rake your beach, what do you do with the seaweed?
We put it back in the water.
Okay.
That's
And,
where it came from.
yeah. And then her also question was, other years, have you used the Mass Audubon?
Yes.
We're very close to Mass Audubon.
I've been
Okay.
to the property before, and piping plovers have been there in the past, and they have worked very well with us and had a letter of commendation from them in regard to that.
And do you plan to still use them?
Absolutely.
Okay, no other comments.
Thanks, Carolyn. Ernie?
No, I have no comments. I guess there was one other question Amy had here about once a week. Is that what you said you rake once a week?
Actually, technically during the season, July and August, we take the seaweed away from the shoreline every day. But it's done by hand, not by machine. It's not the entire beach. It's just a shoreline to keep people so they can have, put a towel down or a chair without flies and everything around the seaweed.
All right. But again, you just rake it back into the water, I assume.
Exactly.
Yeah. Okay. All right. No other comments.
All right, Stan?
Yeah, I just heard the comment you made that you raked the sand out of the dune back up to replenish your beach.
No.
Oh, that's, well, again, your voice kept breaking in and out, so it's hard to hear parts.
No, we have beach fencing that goes up in the winter to keep the sand in place.
Okay, so go ahead, finish it.
Yeah, basically what we do is reclaim the sand at the edges of the dunes, back to the center of the beach. It creates dunes, actually. It builds the beach rather than letting it disappear.
Okay, because what I heard was, that you were pulling it out of the dune onto the beach.
No.
That's what I was questioning. Okay, I'm all set.
All right, John?
So are you saying that the only raking you're doing is seaweed along close to the water? You're not doing any other raking on the beach?
We don't have a beach, a mobile beach rake or anything. It's just the edge of the water line. When we do happen to get some seaweed that comes in every now and then. If you get a north wind, we're fine. Southwest, then you have a lot.
Okay, all right. That's my only question. Thank you.
All right, thank you. Any comments from members of the audience? And there is a note from Amy asking when the snow fence is removed. Is that by April 1st every year?
Well, Brad, that's interesting. You should ask that question. It really depends on when we're able to get, Todd's man. I take Todd, the skipper, when he can come. Typically, the fences are removed before Memorial Day because we want the beach in order by Memorial Day. But if we take it out too soon, we'd have a storm and we'd lose everything that we put, in place. So by Memorial Day.
Okay. All right.
I think the April 1st, Brad, I think the April 1st date is because of the plovers. I mean, if you're up there removing fencing,
right,
and the plovers have decided to nest, so no problem.
If we have plovers, we just leave it alone.
No, we can't.
We work with this, there's Audubon and they come down and fence it off, and we just leave things in place.
Actually,
Oh, okay. All right, but I mean, Amy's comment is that she has an April 1st date here that seems fairly permanent. I mean, I don't unequivocal, I think. So I don't know how to address that. If you're saying Memorial Day, that's a whole month later, and I don't think that would be acceptable to her.
No, the only way that I would say is, as first as we did you, we aren't touching the beach if there's a nest. If there's, and I'm sure you all know what a bedding plover nest looks like. It's actually a simple hole in the middle of the sand of the beach. It's very, very hard to see. But Audubon is very good at recognizing these. And already I was on the beach day before yesterday, already we have Audubon lines up all the way from the Main Street all the way down to Richmond. And their eyes are on our beach and our neighbor's beach. The history has been over the last few years, there have been many more nests in Main Street and Snow Inn Road. And there have been going further to the west, which is because of the tide line and the shortage of beach. But if Audubon sees a bird nesting on our beach, there's no way he'd ever even consider it. And you guys and so Audubon will allow it.
Yeah, the plovers are there now.
If there's a nest, we like to wait until they've hatched. They have to wait until they do.
Yeah. All right, I'm not sure how to address that, Brad. You know, given the comments that we have here, and you know, I'm not comfortable giving a Memorial Day extension on that removal requirement.
What does the present permit say right now on the removal? Or the previous permit?
I think it was.
Does it have it?
Yeah, the previous permit, I think, went up till Memorial Day. It's technically the beach next door to us, and then the property owners to the west side of us. Todd Lee did all of the beaches at the same time, and the same caretaker is doing the work as he has every year, and he won't do the work until he gets the approval from Audubon.
So Ernie, I think, you know, maybe a condition that requires them to coordinate with Audubon is probably better than having a hard date. It seems they have an interest in avoiding, you know, April storms that might disrupt things. Is that reasonable to have a condition that talks about coordination with the Mass Audubon? John?
You know, the problem there is if they want to remove the fence by Memorial Day and there are birds already there, last summer the birds weren't gone until the end of July, so they can't remove the fence.
No, we can't. No, we can't. And we don't.
Memorial Day. It has to
3 years ago, we had a situation with the fence.
Excuse me. That's all. So, and it's too late now already, right? Because the birds are here. I assume they're down there. They're certainly at Red River. So we can't require them to remove the fence now. I don't believe, unless Ernie, you see it differently. So I'm not sure what the right thing is here.
My suggestion would be that I'm more than willing to let anyone, obviously from the Conservation Commission, to oversee this, but Audubon as well. We don't want to remove the fence, and if there is a nest on the beach, we absolutely cannot remove the fence. These fences go sort of parallel and zigzag the center of the beach, and the only purpose of those fences is just try to keep the sand on the beach and not have to pull so much of it out of the dunes. So it's kind of been a standard procedure for 30 odd years.
What also has happened too is and so we've you know, the beach builds, and actually it's built higher than the town beach. When we ever have a flood tide or something, it seems to come into the town beach, which might benefit by putting up beach fences in the winter to hold the sand in place. But if the birds do nest, we of course are aware of them, and if it's dynamic, we'll work with them and work with the Audubon Society and however it needs to be worked with. But I think it's actually much more interesting to have a floating date rather than a hard date if there happens to be birds there.
Oh, you're still muted, Ernie.
Yeah, I was saying, I like your suggestion. Any work has to be coordinated with the Audubon. So that's acceptable to me.
Okay. Any further comments or questions?
Yeah,
go ahead, Stan.
Okay. Well, can we kind of approve this permit, but with clarification when Amy comes back as to that fencing date? Because yeah, I'm not sure. I mean, she definitely has it in here, and I'm sure she has a reason for it. And I don't know if it's the plovers or what, but I'm kind of like with Ernie. I'm kind of leery of approving this without knowing what her rationale was, unless we can approve it with potential, you know, Amy's comments after, you know, and included in the permit as far as the date.
I just like to, if I may, I'm sorry. This is just, it's a renewal of a permit that had already been granted in 2015. So, I mean, we've lived with this before and the board has lived with it before, and it's really nothing brand new.
Well, I didn't hear what your permit said as far as dates.
It's a 3-year permit and we didn't, and that's how it gets renewed at 3 years.
No, I understand that, but what did it say as far as fencing in your old permit?
I don't have that in front of me right now. Amy,
that's why I'd like to have Amy clarify as to what should be in there in terms of the snow fence.
Well, Stan, you know it's to do with the piping plovers, and you know there's a practice they followed for many years. I'm fine with having language that says that they need to coordinate that fence removal with Mass Audubon.
So there's a document in Dropbox from Mass Wildlife, and there is a provision in it, number 4, that talks about seasonal sand fence. And it states all sand fences shall be removed from the beach during the shorebird nesting season, April 1st to August 31st. The seasonal sand fence may be installed after the shorebird nesting season is concluded, after August 31st, and removed prior to the onset of shorebird nesting, April 1st. So it's specific in here.
Ernie, does that language indicate that the fences should be removed by April 1st? They should be removed when the pipe and plovers are done with their business.
It says all sand fences shall be removed from the beach during the shorebird nesting season, April 1st to August 31st. This is the prior order that was issued to you gentlemen back on March 30th of 2021 from the Division of Fisheries and Wildlife.
Okay.
I think that addresses it.
Yeah.
I have no arguments with that. I only say this because I think it's important. We don't know at this moment whether we may already have a nesting situation going on. But we also know that on the neighboring properties, you know, there are fences, and all of those fences would have to obviously go along with the same guideline. I'm not in any way against taking the fence down earlier. I just know that it's going to be a little bit more work because we're going to have to pull more sand back if we have a storm. But it's up to the board. It's up to the board. We'll go by the rule.
Yeah, well, this was the notice that the division sent to us. It's addressed to the Harwich Conservation Commission. As I say, it's dated March 30th of this year. So I think that sort of binds our decision.
John?
Well, I just want to clarify another point which is confused here. You answered a question a little bit ago, a very specific question. I forget who asked it, but someone asked you, are you pulling sand out of the dune? And you said, no, absolutely not. But twice now since then, you've referred to how much sand you have to pull out of the dune. So, you know, if we issue a permit here, I think we have to be explicit in the permit that there is to be no sand removed from any dunes. And I hope that I'm just confused and you're not telling us both things.
If I can do anything to clarify, just ask me a specific question and I'll do that.
Okay, I'll ask you the same question that someone asked you before. Are you or are you not at any time removing sand from any of the dunes on your property and pushing it onto the beach?
Okay, here's the answer to that question. Any sand that has any growth in it is not being removed. So we are not removing the dunes. We're not touching the dunes. We're rearranging the sand, only the sand. Nothing that has any growth or any wildlife is being touched. We're just regrading the sand into the middle of the beach because the guests, you know, get cut on the shells
And so with the zone, it's just to smooth out the beach. That's all it is.
All right, well, I think we are obliged to follow the Division of Fisheries and Wildlife's recommendation. And I guess that can be viewed as an update, more information, so it's a contemporary update. Would one of the commissioners like to make a motion on this notice of intent?
I'll make a motion to approve the beach maintenance for 4 Braddock Street with the provisions that dune sand is never touched and the sand fences are removed April 1st.
Okay, could I have a second, please?
I'll second that.
All right, seconded by Stan.
May I make an amendment to that motion or suggest one, Carolyn? And that they also are required to have a representative from Mass Audubon present whenever they do any raking between August 1st and the end of, or early August, April 1st to early August.
Wait. Raking, just that is very broad and it's a good sized beach. And I don't know as Mass Audubon would want to come down and watch them rake every morning.
Yeah, I don't think they would.
But I just have a point of information. I mean, the town rakes the beach with a machine every day in the summer. And we don't do that. We just move the seaweed away so guests are. So the town does much more.
The town's so much more aggressive than we are. And they're right here.
Yeah, I agree with you.
I mean, you've got a massive machine that races up and down the town beach. And all we have is the little boy with a rake.
I totally agree with that. This is the beach I go to. No, so possibly that we include in that they cooperate with Mass Audubon in protecting the piping plovers.
Yeah, that's fine, Carol.
All right, any further discussion?
Well, again, just in our conditions, I think, and that's what we're really talking about, I think, is the fencing by April 1st. And again, I'm still a little bit fuzzy as to what you're saying. You're shifting sand around. I know you're saying you're not taking any sand with vegetation in it. I'm saying no sand that comes off the dunes, period.
That's fine. That's fine. No problem with that.
All right, so let's vote on this by roll call. All those in favor say aye. Those opposed say nay.
I think we need a second.
Oh, you didn't get a second? Well, I'll second your motion, Carolyn. And then I'll ask for votes by roll call. All those in favor say aye. Those opposed say nay. Starting with Jim.
Aye.
Carolyn.
Aye.
Ernie.
Aye.
Stan.
Aye.
John.
Aye.
Mark, I forgot you've changed your place. Mark Coleman?
Aye.
Okay, myself, Brad Chase, aye. The motion carries 7-0. Thank you very much.
Thank you, sir.
Have a wonderful evening.
Appreciate it, Brad. Thank you all.
All right, good luck. Okay, next on the agenda, we have a notice of intent for 0 Old Campground Road, map 30 parcels C6, C7, C8, and C9. It's a proposal for a new dwelling. Do we have a representative here tonight for the project?
Yes, Mr. Chairman, John O'Reilly here. I don't see Paul Shea on the call. Is he out here somewhere?
Yeah, John, I'm on. Can you hear me?
Oh, I can hear you, Paul. Thank you. Thank you, Mr. Chairman. We were here a month ago or so. The commission this will be the third time the commission will have reviewed this project. The commission initially had asked for several variances. One was an elimination of a paved driveway. Another one was tightening up of the limit of work line. And another one was to look into providing enhanced treatment to the wastewater system. And we had done those revisions back in February. Plan is revised February 10th. And as I said, we were here about a month ago, and there was some question on the potential impact to the interests of the wetland relative to habitat. And also there was a question from Amy regarding a vernal pool. So the applicants have gone out and engaged Paul Shea of Independent Environmental Consultants, and he is on the call. He has visited the site and has prepared a document which we had provided the office. With that, I'm going to just turn the floor over to Paul so he can narrate his report, and then I'd be happy to answer any questions on that you might have regarding the plan, or certainly Paul would be available. Thank you.
Okay, good evening. My name is Paul Shea, and I'm with Independent Environmental Consultants. I was asked to look at a couple of things at the site. I was asked to look at the wetland resource areas, the buffer zones, in particular where the proposed gravel driveway leading into the proposed new house off of Campground Road. At one point, it passes in between a bordering vegetated wetland, and to the north of the driveway is a small isolated wetland. And there was a question raised whether the small isolated wetland is classified as vernal pool habitat. That was the first thing I was supposed to look at, and also just pretty much overall, what are the impacts on the wetland resource areas from the project. So on, I believe it was March 9th, I did a site inspection of the isolated pooling area. Again, this is the small wetland, which is near it's at the northern property line, and it's located to the north of the driveway and to the east of Old Campground Road. Can you folks hear me? I keep hearing this lot of noise in the background. Hello?
Whoever talking needs to mute. Ernie, can you mute? There's a lot of noise coming from your mic. There we go.
Okay, can you hear me now? Fine?
Yes.
Okay. So the small wetland to the north of the driveway, we looked at it, approximately had about 2 inches of water throughout the pooling area. The maximum depth of water was 4 inches. The pool was completely quiet the whole time I was there reviewing it. There was no signs or sounds of any, aquatic wildlife species, no signs of wood frogs or not even string peepers. But within the pool water was actually very clear. You can see at the bottom, absolutely no evidence of any egg masses or anything like that. The wetland or the small pooling area is so shallow that it just, as soon as the vegetation starts to come to life and starts pulling the groundwater out of the ground, an area like that is just going to dry up incredibly quickly. So in my opinion, it doesn't have enough water to really function as vernal pool habitat. The other thing is that small isolated wetland to the north of it is a large coastal wetland, which is contiguous with the Herring River, which is a tidal wetland, and it's the small pool area is actually in the 100-year flood zone. It's in land subject to coastal storm flowage, which means it has the possibility of coastal saline waters getting up into this small pooling area, which would completely wipe out any vernal pool situation if it was there. But it every small area that collects water in a forested area doesn't mean that it's vernal pool habitat. And so this one does not qualify as vernal pool, and it doesn't have enough water to qualify it to actually support the wildlife species and aquatic species which typically inhabit vernal pool habitat. The proposed gravel driveway comes in off of Campground Road, literally midpoint between the southern edge of this isolated wetland and the northern edge of the bordering vegetated wetland. The bordering vegetated wetland to the south of the driveway, actually, when you drive in Old Campground Road, you're actually driving right next to a section of the bordering vegetated wetland. It's right beside the road as you're approaching towards the subject property. So in the proposed project design, the way John has designed it, basically there are no proposed alterations within the 50-foot buffer zone of any of the wetland resource areas, that being the isolated wetland, bordering vegetated wetland, coastal bank, or even the larger, obviously, salt marsh wetland located to the north and to the east of the proposed house. The closest the wetland alterations are is approximately 60 feet off of the isolated wetland from the driveway. And from the bordering vegetated wetland, it's more like, 70 feet. It's a pervious driveway. It's going to allow for infiltration of runoff. There's not going to be any stormwater runoff generated to go into either wetland. The buffer zone, 60-foot or 70-foot buffer zone is of those wetlands is going to remain in a forested state, and which will allow protection for the wetlands themselves. And the house itself is outside the 50-foot buffer zone all the way around. I think the closest point the house is towards any of the wetland edges is more like about 75 feet or something like that. But basically, in terms of wildlife habitat, the most important wetland here is actually the coastal wetland, which is contiguous with the Herring River. It's a huge wetland system, salt marsh. It does include some areas of fringe wooded swamp that drains down into the salt marsh. But in terms of wildlife species, that edge of that coastal wetland to the forested upland areas next to it is very important in terms of wildlife habitat and wildlife migration around that corridor. And there's no proposed impacts at all from this project within that area. So in my opinion, number one, the small isolated wetland, it's not a state wetland. It's not a bordering vegetated wetland. It is classified as a wetland under the Town of Harwich wetland regulations. And it's isolated, but it does not contain vernal pool habitat. And the proposed design is maintaining the 50-foot buffer zone. It's actually maintaining a 60-foot buffer zone. I'm happy to answer any questions. Basically, I've got a project with no proposed impacts within any 50-foot buffer zone of any of the wetland resource areas within the subject property or even the abutting properties. The distances away from alterations are more like 60 to 70 feet. And in some areas, they're maintaining, 100-foot buffer zones from the wetlands with no alterations. And I'd be happy to answer any questions.
Thank you. All right, let's go through questions and comments from the commissioners, and we'll start with Jim.
Just to clarify one thing, it appears the driveway goes right through the coastal bank itself. Is that correct?
I believe at the beginning of it, there's a section of it that it crosses through the coastal bank, correct?
Just to clarify, is a direct impact to a resource area itself, being a coastal bank. Go ahead, Paul.
It's I believe, though, in the section where that coastal bank is, or what's by elevation, the coastal bank is by elevation. And I believe even some of the existing roadway, that impact is in that coastal bank area, the end of Old Campground Road. But yes, a very small area of the actual 12-foot wide gravel driveway does go through a section of the coastal bank.
Okay, thank you. Just another comment on the isolated wetland as to whether or not it's a vernal pool. I just disagree with the water level disqualifying it. Because a classic vernal pool actually is dry in some years, and then some years will have just several inches of water. Other years might have feet of water, but that really is what creates a vernal pool is that it dries up. And I'm just not 100% on that being qualified.
Well, first of all, for a vernal pool situation is that in this particular one here, this wetland's going to hold water during every wet season and into the spring months. That's the amount of water in there. This thing is going to be bone dry by Memorial Day. Most vernal pools that are functioning as vernal pool habitat are going to have more. When I go out there around, and my vernal pool work is typically in the month of March into the beginning of April. And when we go out there, typically a vernal pool is going to have 10 inches of water and maybe even 16 inches of water at its deepest point. Maybe the average elevation of the water going through it is, more like about 6 inches. That pool, most of those pools will completely dry up in the summertime. As soon as you get to the 4th of July, that it's bone dry. You never even know there was water in there, except that you can see what was once the wet leaves on the bottom of the pond during the wet season. That's the whole point of a vernal pool. They literally disappear and then they come back every year. But not every area that can hold a little water within the forest is a vernal pool. And that's what we have here. We certainly have a clear pooling area within this wetland. And you've got the edge of the wetland, which was flagged by John O'Reilly and Associates. But the pooling area is much smaller than what the flagged wetland edge is. And the amount of water in it, once the vegetation, the deciduous vegetation starts pulling that water out of the ground like it is right now when we start going into leaf out conditions, that pool is going to dry up very quickly. In my opinion, this kid doesn't hold enough water to function as a vernal pool habitat.
Yeah, I'm just also very familiar with vernal pools, and there's one in my neighborhood, and this year it actually is dry. It's not gonna function. There's not gonna be any frogs there, or salamanders laying any eggs. But last year, in the previous 3 years, it's been very active. So I haven't heard or seen anything that necessarily disqualifies that. Just wanted to point that out. Overall, as my comments were when this was originally proposed, I feel like this is a really impactful job. As was mentioned, this area has a lot of wildlife habitat. It's basically all high value. Just small areas of marginal upland in between a lot of wetlands, and this project as proposed really fragments that whole area. So those are my comments.
All right, thanks, Jim.
Well, again, just one thing is when I look at a project like this going in, I have wetlands all over the place when I go out here, on property and off property. But when you can design a driveway off an existing roadway to a proposed new house and have no alterations to a 50-foot buffer zone, that's fairly unusual these days. In most cases, we'd be asking for variances to work within the 50-foot buffer zone. This is unusual that they've been able to keep the impacts down because everything is outside the 50-foot buffer zone, which is what every conservation commission wants. Technically, they're not asking for a variance here because they're not working within the 50-foot buffer zone. You have to remember that with this project. And I'm working in every town in Cape Cod. The regulations are actually very similar in all the towns in terms of the 50-foot buffer zone. And Mr. O'Reilly's got a plan before you where he's not altering any area of the 50-foot buffer zone. It's all going to remain in natural habitat, just the way it is today.
Mr. O'Reilly, can you confirm this project is not asking for a variance?
Okay, can you hear me?
Yes.
Yeah, I think what Paul was trying to say is that we're not looking for a variance for any of the freshwater wetlands. As we had made a presentation, there is a coastal bank that surrounds by elevation the outer peninsula where the house is being proposed. So we are driving through between the two wetlands. We are within land subject to coastal storm flowage, and we are passing over a coastal bank coming up to the house location. So in that sense, for variance.
Yes, that will require a variance. Okay, Carolyn.
And I'm sorry to see the driveway going over a coastal bank. I guess there's no other way you can do it. I don't think that the fact that a driveway is, other than going over the coastal bank, that a driving through there is actually separating the wilderness, so to speak. I think any animals and such can cross that driveway. And so other than the location of the driveway, I have no other comments.
All right, thank you. Ernie?
No, I have no comments on this. I think we've looked at it. The last time we looked at it, I was favorably inclined to it with the changes that they were proposing for the septic system. So, no comments. Thanks.
Stan?
No comments.
John?
So can you just confirm that the plan that I'm looking at, which we had in a February meeting, it's dated the 15th of January, is that the most recent revised plan?
John, that was the original date of the plan. Right above the names, Nan White and Lee Colton, there should be a revision date, February 10th, 2021.
Where are their names?
Lower right-hand corner of the plan is the title block.
Oh, yeah.
Right above there should be a revision date.
Right. I have it. Yeah, okay.
And that revision date is the one that Ernie was just referring to as far as adding the enhanced treatment.
Yeah. Okay. I don't have any further questions. Thank you.
All right, Mark Coleman.
I have no remarks. Thank you.
All right, thank you. For myself, I have concerns about impacts to coastal bank, wildlife habitat, isolated wetlands. I think the bar needs to be quite high for variances. Either they can be issued with no impacts to interest of the acts, bylaws, or due to hardship. And I just don't see this as a case where a variance should be granted myself. So any comments from members of the audience? All right, any additional comments from commissioners?
Through the chair, Brad?
Yes.
John O'Reilly here. and please tell me if I'm inappropriate here. Obviously, we did get some feedback from two commission members that had some concerns, but Ms. White and Mr. Colton is in the process of purchasing the property, and I'm having trouble reading all the commission members and where they stand with this project. So, could I would like not to have the project denied if that's where the commission is going, without letting Mr. Colton and Ms. White review that issue with the owner of the property, Mr. Colson. So I'm just having difficulty reading the board, and I would indulge a straw poll if I'm not off base.
Yeah, no, I don't wish to have a straw poll. I don't think that serves the interest of this process. You know, you've heard the comments from everybody. I mean, do you wish to have a continuance to discuss this with the potential buyers?
No.
Excuse me?
But I didn't hear your response.
I thought someone yelled no. Well, I really would like not to have a no vote on this, and if that's where we're headed, I'd like to have a continuance, so I'd have a chance to review that with the applicant as well as the property owner.
Yeah, that's your purview. You know, this is our third hearing, so we have discussed it, you know, quite a bit, and there have been some concerns expressed, you know, each time by some members, and then other members have had, you know, a few comments. So I feel like we're close to the point where we can rule on this. I don't think there's any new questions being asked. So I appreciate all the work that's been done to address the past questions, as well as the questions on the isolated wetlands. So I do appreciate all that effort, but I think that either we're ready to entertain a motion tonight, or if you want to go back and discuss it with the potential buyers, that's your call.
Brad, could I?
Yes, sure.
Are we concerned about anything other than the driveway?
Yes, I think you've heard from Jim and myself concerns about impacts to the coastal bank, wildlife habitat, and
No, I know, as far as their plan. I understand all the concerns are impacts, but which locations are we concerned that they're impacting the most?
I could speak to that somewhat, Carolyn. They also, you know, basically the whole project is in a 50 to 100 buffer zone, and there's no mitigation proposed. You know, the septic is theoretically outside of 100, but it's, you know, it's this little tiny triangle that, if it's out, I mean, it's hard to say, but, you know, with water levels rising and whatnot, it'll certainly be well within soon. So, but, you know, essentially the whole project is pretty impactful. You know, we're putting a house, a driveway, some sheds, a septic, and clearing land in a pristine buffer zone. And there's no mitigation proposed. There are, you know, definitively impacts, and there's no mitigation, which to me does not comply with our regulations. So that's my take on it.
Jim, my understanding on the mitigation was that the existing vehicle tracks that go through that property were going to be replanted to offset some of the other impacts that we're seeing here.
Yeah, that is correct. There is mitigation provided as far as planting of the existing vehicle tracks that traverse the whole property. We are providing an enhanced treatment which knocks the nitrogen down, which would be very important in a coastal environment. With regards to groundwater separation, we are almost 8 feet above the estimated high water as calculated through the Cape Cod Commission. So from an environmental point of view, we are stepping up, as they say, and treating our effluent to a higher level. It is only a 2-bedroom home. It's designed to be a 2-bedroom home. System is only designed to accept the 220 gallons from the 2-bedroom home. So I think we do address the wastewater component of this. And as far as hardship, this lot has no other points of access onto it other than from Old Campground Road. I'm going to ask for a continuance, Mr. Chairman. 2 weeks, please.
When would you like to continue until?
2
April.
weeks time.
Okay, April 17th. Okay. Well, then I move that we continue hearing for 0 Old Campground Road, map 30, parcels C6, 7, 8, and 9 until April 17th, 2021. Have a second, please?
Second.
All right, seconded by John. All those in favor say aye by roll call, starting with Mark.
Aye.
Jim. Aye. Carolyn.
Aye.
Ernie.
Aye.
Stan.
Aye.
John.
Aye.
And myself, Brad Chase, aye. The motion carries. So, thank you. We'll see you on the 17th. Okay, next on the agenda, we have a notice of intent for 23 Snow Inn Road, map 8, parcel P2-0, installation of additional synthetic turf at the Witchmere Beach Club in place of the natural lawn that was previously approved and associated mitigation work. I think we have Mr. Singer here tonight.
Yes, good evening, Mr. Chairman. For the record, Andrew Singer, attorney for the applicant. With me is David McNeville from Coastal Engineering, as well as Dave Hawk from Hawk Landscape Design, and Mike Charlotte from Witchmere. Given the time, I'm going to present hopefully briefly, and then we're all here for questions. I would like to point out just what we're here for is a very discreet request as part of the beach club, which is around the swimming pools themselves, the area that was all concrete before. You had approved just under 8,000 square feet of Players Best natural lawn. This is a heavily trafficked area, and there is significant concern that as the project's being built out now, there's significant concern that this area is going to be just destroyed because of all the chef's lounge on it, people, and it's going to require more disruption to the resource area. So what the applicant would like to do is to change this 7,946 square feet of area, this lawn panels around the pool, to be sin lawn. You had approved 2 555 square foot panels of sin lawn closer to the beach on the deck. We're proposing to not do those and just make that deck. And so there'd be a net increase of 6,836 square feet of sin lawn. However, the full amount of 7,946 would be mitigated because, as you know from prior discussions with you, although the sin lawn is very permeable, as the studies show, it is considered by the town at this point as impervious. So therefore, the proposal is to use this sin lawn and then to mitigate for it. As far as the sin lawn itself, so there's two questions. One is sin lawn and one is the mitigation. So just talking about the product itself, you do have Amy's comment that she does not feel that the product would have any adverse impact on the wetland resource areas or their interests on the lot, according to either the state act or your bylaw. So she is supportive of the Sinlon installation here. In addition, she has a question on mitigation that I'll discuss, but she's supportive of the product itself. In addition, the Conservation Commission actually approved Sinlon on this property over at the residential condominiums back in 2007. It was SE 32-1643, and you issued a certificate of compliance for it in 2009. So that Sinlon in patches over by the condos, the residential condos, has been in there for many, many years, and it has held up very well, and there are no problems with it. Finally, as to the Sinlon itself, we want to do some more research because we know you had questions when we discussed this many months ago during the prior hearings. We reached out and had a call with the Encore casino facility up in Everett in Boston, which is right on the harbor, and which has more than 60,000 square feet of Sinlon, synthetic lawn, that they use right adjacent to the waterfront. And so we thought they would be a very good example to share with you. That installation of that 60,000 square feet or so of material was approved by both the Everett and the Boston Conservation Commissions. And there have been no problems in the 2 years that it has been there. In fact, the chief engineer for Encore stated that there's less migration of material with the Sinlon than arises from the carpet fibers in your house when you're walking. So he was extremely supportive of the durability, the environmental benefits, and the low maintenance of the Sinlon synthetic lawn applications. And so I believe that given the benefits to the resource area here, and certainly no harm, as Amy found, to not having the grass that's going to be there, natural or not, it's grass and it's going to get torn up and have to be replaced. It also has to be irrigated. And that's the reason we're here before you this evening, is that as they build out the beach club, they're at a make or break point, which is they either need to install the irrigation lines or not. And with your approval and then the planning board and the Board of Appeals approvals, they would like not to. They would like to not have to do the additional irrigation and the additional maintenance that's going to take place in the pool area, which can be very disruptive as well as costly. And as Amy noted, there is no environmental detriment that she sees under either the act or the bylaw. Now, the question does come up about mitigation. We have proposed that the required amount of mitigation, which is approximately 19,000 square feet, and David McNevich could go through the calculations with you, but he did the entire calculation based on the different resource areas that are impacted. We have proposed to convert more of the regular lawn area that's under the main lawn and the parking, some of the parking area, to be the player's best. Amy did have some concerns about that. She frankly didn't agree with that. She agreed with the Sinlon, but she didn't agree with the mitigation. She proposed two possible alternatives, which given timing, one of them given timing just doesn't work in this case, which is offsite mitigation. That is something that's potentially allowed, but it's not feasible for the applicant or for us to offer to you now. She also suggested the possibility of some additional on-site mitigation. Now, she suggested the beach area, which is not something the applicant can do. The remaining beach that has not already been converted for mitigation, they need for the business use of the property. However, we were able to find another potential application if the board so desires. Now, we hope that you'll agree with the proposal that we've made. If you do not, over at the residential condominiums, where there is already some Sinlon, there is significant lawn area that is fertilized lawn, and which it does not have to, at this point, because it's been separate from the commercial projects, does not have to be converted. There is the opportunity to convert the required amount of lawn there for that purpose. And we do have a potential sketch plan we could show you if I can figure out how to share screen. But that would be, you know, if necessary. So that's the presentation. I hope I didn't speak too quickly. I do realize it's late, but we are asking your permission to approve the 7,946 square feet of sin lawn around the pool with the mitigation that we are submitting. With that, any of us are happy to answer any questions and give you any more detail that you may want. And we appreciate your time.
All right, thank you very much. All right, let's go right into questions from the commissioners, and I'll start with Mark Coleman.
Actually, this seems like a fairly reasonable plan. I like the idea of the sim lawn down around the pool area. I understand the maintenance factor, and I think it's a good alternative overall. And the offer of the mitigation, to me, seems like a good opportunity at both ends. That's all.
Thanks, Mark. Jim.
Well, yeah, I kind of agree that the sim lawn makes sense around the pool. I don't think the grass was going to work out either way, basically. I do have some questions as to mitigation, though. Now, the way I understand it, the entire property, fertilizers can't be used anyway, or at least any part of the property that's within any sort of buffer zone. So, are we really changing anything with what you're proposing to the north of the pool area, or was it already going to have to be that way anyway?
Through the chair, Mr. Donovan, that you're hitting on the comment that Amy raised, which is she felt that the area within the commercial part of the property that is north of the pool area was something that we had discussed with you long-term, ultimately converting to Players Best at some point. We have proposed to convert it sooner as part of this proposal. The alternative I mentioned is something separate because it's not part of something that we've previously discussed with you. But to answer your question, our rationale for the original suggestion of the mitigation north of the pool area is that it would be speeding up the potential ultimate conversion of that area.
Okay, thank you. Yeah, the way I understand it is that you didn't necessarily have to convert anything, but that no fertilizers, herbicides, etc., could be used really as of the start of this project. So they shouldn't be being used even at this time. Would it be possible for you to show us that other area by the residential condominiums, the sketch plan you mentioned?
I can try, certainly. Just in further response to your question, while the area may not be fertilized now, the Players Best actually holds up better for that. But let me see if I can. I hope, Mr. Chairman, that I have the authority to try to do this.
Yeah, we'll see. I'm not sure.
Can you see anything? Can you see my plan at this point?
Yes.
Oh, okay. I did it. Whoops. Can you still see it, or did I get rid of it?
Yeah, you got rid of it. Bring it. You can probably, I think you minimized it.
There we go.
Can you enlarge it a little bit?
I will try, yes. I'm not able to see all of it, but can you see it clearly at this point?
Yes.
Okay. So to Mr. Donovan's point, these are the residential condominiums. I might have made it too big now. On the water side, on the east side of the Harbor View and the Seaview buildings, those are where there are areas of sin lawn already, not all of it, but part of it. And then you can see the areas hatched out that Dave McNevich has put on to this plan.
Oh, okay, thank you. Well, yeah, I would support the revision with the mitigation being as is on this sketch plan. So thank you. Those are my comments.
All right, thanks, Jim. Carolyn? Abstaining?
Yes, I'm going to abstain.
Okay, thanks. Bernie?
Yeah, I noticed one other change that's on the plan that you presented to us is to propose, well, actually replacing the existing sin lawn down on within the 50-foot buffer and replacing that with decking. I'm not in favor of that. Again, we generally discourage structures within the 50. I'm not sure what was there before, but to put decking there is, in my mind, that's problematic. I have a question for you, just since I've got the experts here on the phone. In walking the beach, there's the new structure that's going up as part of this. It's a 2-story structure with like a, I don't know, 8-sided room at the north end of it. What is that?
That is, through the chair, that is the replacement beach club restaurant building that you approved several months ago.
The proposed beach grill, is that the grill that's on the plan here?
Yeah, I get mixed up with the names of the different buildings. I'll ask Dave McNevich. Is that the one that's called the Beach Grill, Dave?
It's called the Beach Grill.
Yes, sir.
It's interesting, when we approved that, I thought of a grill as being something a whole lot smaller than that. That thing is immense. I'm honestly very, very surprised to see the enormity of that building that obviously we approved, but had we seen the plans for that as opposed to just a description of it being a beach grill, I'm not sure I would have been in favor of it. So that being said, that's the first comment is the decking replacing the sin lawn down within the 50. I'm not in favor of that. The replacement lawn that's been proposed as mitigation, I'm more in favor of what you proposed around the condominiums, which is closer to the resource area than what we have here. And with that, I have no other comments.
Mr. Chair, could I respond just to help clarify a couple points?
Yes, please.
So you know, for the two 555 square foot areas of sin lawn down by the beach, those are actually on what was existing deck, and we had proposed to convert the deck to the sin lawn. We're just now asking to make it back to the deck that it was. So it's not new impact on and it was mitigated for originally. So it's not new coverage or new impact to the resource area. It's just changing one covered area to another, which had been decked before. So if that helps on that. As far as the beach grill, just I know it's not part of this, but just to clarify for your comment, we had submitted and you did review full elevations and floor plans in perspectives of the building. So, we were very upfront with what the proposal was. But as far as yeah, thank you.
I must have missed that meeting, I guess. Okay.
All right, thanks, Ernie. Stan?
Yeah, Ernie, I think from now on, instead of just a drawing, we need to have like a model, to get a better representation, because I've been surprised in a number of cases where the final structure is a lot different than what I imagined, not just this one. But I have no other comments.
All right, thanks. John?
Yeah, I'm not so concerned about the taking away the 2 small patches of sin lawn and replacing them back to decking, as long as it's pervious decking. And I do favor the revised proposal for the lawn replacements out by Seaview and the captain's house, I guess, is what it is in that area. Thank you.
All right, thank you. Any comments from members of the audience? All right, I'm comfortable, having these revisions put in place with a revised plan in terms of the mitigation and moving on this tonight. Any thoughts in opposition to that among commission members? I think we have pretty good agreement on the mitigation proposal. All right, so folks are okay acting on this tonight with the assurance we would get a revised plan? We don't have that plan, right, Mr. Singer?
That is correct. I think the revised plan you're talking about is just us. I would email this to the department. I can't stop sharing screen at the moment somehow, but we will email this to the department. Yes.
Okay.
This is the plan. If this is the mitigation that you approve, this is that plan.
And can you add square footage to that plan so we have those numbers documented?
They are on the plan. If you look, it's there are two areas, and there's a total line there that says 19,622 square feet. Let me make it bigger.
Okay. Yep.
So the dimensions are on the plan.
Okay. Yep. Small print.
And just for clarification, we will submit this. It does have the areas. We will revise the plan, the site plan that was submitted with the proposed mitigation. We'll remove that proposed mitigation, and we will update the mitigation being provided in the table as well.
Okay, no, that's good. All right, well, hearing no further comments, if one of the commissioners would like to make a motion at this time.
Yeah, I'll make a motion to approve the notice of intent for Witchmere Harbor Real Estate, 23 Snow Inn Road. Installation of synthetic turf in place of natural lawn with mitigation to be as shown in the sketch plan.
Got a second, please?
I'll second.
All right, seconded by John. All those in favor by roll call say aye. Those opposed say nay. Starting with Mark Coleman.
Aye.
Jim.
Aye.
Carolyn.
Abstain.
Yep. Ernie.
Nay.
Okay. Stan.
Aye.
And John.
Aye.
And myself, Brad Chase, aye. So the motion carries 5 to 1 to 1. So thank you very much, gentlemen.
Thank you. We appreciate your time.
Thank you all very much.
Okay. We have a notice of intent next on the agenda for 34 Red Pine Drive, map 82, parcel X18. It's a proposal for a single family dwelling. Do we have a representative here tonight for the project?
Yes, thank you, sir. Good evening, Asa Mintz, AJM Site Design. Here for Martin Letty. This is an NOI for a new construction, a new residential dwelling. 34 Red Pines, a 31,000 square foot undeveloped lot. It's a panhandle lot down towards the end of Red Pine Drive. It kind of wraps around number 38 and runs down to Aunt Edie's Pond. There is a bordering vegetated wetland associated with the edge of the pond. That wetland was flagged by Paul Shea, who I believe is still here. Yep, I see him there. Which, obviously projects the 50 and the 100 up onto the property. There is also an area of priority habitat down, which is more or less, it's kind of like a 100-foot buffer around the perimeter of the pond. This is in the Six Ponds District. It's not in a Zone 2, and we're kind of centrally located on Cape here, so we don't have any floodplains to worry about. As I mentioned, we are proposing a single-family dwelling. It's a reasonably sized Cape. It's a 3-bedroom with a 2-car garage attached. In siting this house, we really pulled it back as far as we can away from the pond and maintained, all of our appropriate setbacks and turning radiuses and sort of functionality of the property. The structure itself is 123 feet from the edge of the pond. Is 90 feet from the edge of the flagged wetland. We do have a very modest, a very small backyard, which is the limit of disturbance is 105 feet from the pond and 72 feet from the edge of the wetland. We've got just shy of 2,500 square feet of disturbance within the 100-foot buffer. We do not get into any of the mapped areas, any of the natural heritage mapped areas. And as I mentioned, we're limit of work is about 72 feet from the edge of the wetland. All the septic components on the other side of the building, the closest component's about 142 feet from the edge of the wetland. But the leach field is anywhere 150, 160 feet from the edge of the wetland. It is a pump system and it's a pressure dose system. However, it is not a mounted or raised system. We were able to work the grades in the corner of the property to keep it below grade. And we have 2 stormwater recharge units on the rear corners of the house to handle any of the roof runoff from the house. We also have silt fence around the perimeter, as you might imagine, anywhere down gradient towards the pond or any areas that we might affect. So as far as mitigation goes, we've got, we understand you typically require 2 to 1 between the 50 and 100. And we also understand mitigation can be a little difficult on properties like this. So we kind of we looked at 2 different things. Paul looked at possible invasive species removal. If we had any invasive species that we could take off this lot to provide mitigation and provide enhancement anywhere in the buffer zone or anywhere on the lot. However, there's nothing to speak of in terms of invasive species. So we kind of took another alternative that Paul had recommended and using some of the area of the undisturbed buffer zone and enhancing that area. We have some opportunity in there for plantings in some of the open areas in the buffer zone. So we're showing plantings basically between the 100 all the way up to the edge of the wetland. I don't know that we can necessarily quantify, square footages with this sort of approach, but, we're certainly trying to, making an effort to provide some mitigation with this plan. We're showing about 27 plantings as it is right now inside the buffer zone in the disturbed area. However, that, that could go up a little bit. And it's sort of going to be a field fit type of scenario as when we get into these plantings, where exactly we're going to put them, because waiting for things to leaf out a little bit and see where our opportunities arise. We're also providing some of those native plantings outside of the 100-foot along the edge of the driveway leading out. These plantings are azaleas, sweet pepper bush, chokeberry, low bush blueberry, and huckleberry. We've got a total, right now we show a total of 43 plantings. It'll be no less than that. So I would be happy to answer any questions that you may have.
All right, thank you. Let's go right to questions from the commissioners, and we'll start with Mark Coleman.
I really don't have any questions. Thank you.
All right, thanks. Jim.
So yeah, this one is something we don't see every day, where it's in the Six Ponds district, which has pond buffer regulations that actually have a 300-foot no structure zone. Now it's a pre-existing lot, but that doesn't necessarily mean that it doesn't have to comply with the regulations. It does mean that it is buildable as per our zoning regulations, but there are still specific things in the Six Ponds district regulations, even for non-conforming lots. So that's something to consider. Essentially, they say that the structures should be located as far as possible away from the pond, and that they should have advanced wastewater treatment. Basically, as low impact as possible. Obviously, ideally, we were going for no structures within 300 feet, but as a pre-existing lot, it is considered buildable, but it isn't considered. You could put any building there. It could be a smaller building. It could be pulled back more. And that I think that septic piece is particularly important here. So I just wanted to point that out to everybody. I'm not sure how familiar everyone is with those regulations, but I'll leave my comments at that for now.
All right, thank you, Carolyn.
No comments.
All right, Ernie.
Yeah, I appreciate that explanation, Jim. That was helpful. I didn't realize that some of those requirements were in place. I agree with you 100% that where this is an undeveloped lot right now, any form of mitigation that takes place is basically, you can't mitigate a native lot that's presently here. That being said, I agree with Jim's comment that there's a very small area of the building and the deck and the roof runoff dry well to the west that can and should be moved out of the 100, and that would obviate or eliminate any mitigation requirements that we would have right off the bat. So that would be my preference. Again, as you all know, I've always been in favor of IA septic systems, especially this close to a water body like this. I know Edie's Pond is rated very highly as far as the water quality there. So I would be strongly in favor of seeing the proponents come forward with an IA system on this lot. So those are the two primary comments that I would have at this point. Thanks.
All right, thanks, Ernie. Stan?
I don't know, Jim, going back to your questions, you know, that's good to know. That's new information. So how does, from our standpoint, what impact does this make for us?
I have these regulations in front of me. They're pretty easy to pull up on the internet if you do Town of Harwich Six Ponds District regulations. You go to the pond buffer regulations. You know, I've been involved with these for years on the Real Estate and Open Space Committee, and there's some ambiguity with certain things, but I know when this has come up before with Amy, I mean, the way I understand it is basically the Conservation Commission is supposed to be involved and enforce that 300-foot buffer zone, even though it's just a town regulation. It's not, you know, a state regulation. There's some wording about the Conservation Commission in the actual regulations. Basically, the way I read it is that we're supposed to really consider that this is a very environmentally sensitive area, and that's why this district of critical planning is in place, and try to reduce impacts as much as possible, even on a non-conforming lot like this, basically by keeping the structures as far away as possible, having the nitrogen removal systems, and then anything else that can be done to reduce impacts, just even more than in our normal situations.
Okay. All right, I don't have anything else.
All right, thanks, Stan. John?
Yes, well, I also just thank Jim for bringing up the Six Ponds District thing, which I believe that before I took any action on this, I would like to read those and familiarize myself with them. But that aside for the moment, it seems like at a minimum, as I think Ernie said, you ought to be able to pull all the new structure anyway out of the 100-foot buffer zone to the bordering vegetated wetland, including, as Ernie pointed out, the dry well to the west. Also, just a question for information. The plan is showing a rock retaining wall around, like on the east side, the west side, and the south side of the property. It's not clear what the contours are there, what the height of the retaining wall is. Could you just clarify that?
Yeah, so the retaining wall, we've got a pretty, I won't say drastic slope across the property, but it's a substantial slope across the property. So we're proposing a retaining wall in the front yard, as you said, in the west. In the south, they are nothing over 4 feet here. Everything is basically at 4 feet at its highest, and then tails down back into grade at the end of the walls.
And the same is true on the east side? It's nothing over 4 feet?
It's not over 4 feet. No, it's right at 4 feet. And the same thing applies there, where it kind of tapers back into the grade.
Okay, all right. Thank you. Nothing more.
All right. So you've heard from a couple of commissioners about the potential of moving the footprint back. What are your thoughts on that at this point?
It makes the turn-in a little bit tight with the garage. The turn-in is really what I was trying to hold there on the garage. I can certainly discuss that with my client and rearranging maybe the back of the house there to rearrange that little bump out next to the deck. How do you feel about the deck being inside the 100-foot buffer?
Well, I think if you could endeavor to, reduce your mitigation requirement, that'd be a good thing. And come back with that square footage of the deck. And then we could, with some idea on how to mitigate for that, I think you'd be in a much better position for mitigation.
Okay. Yeah, and you guys are all right with the limit of work?
I mean, I'll speak for myself. I would certainly like to see that pulled back as much as possible. It's really the disturbance that matters, not necessarily the structures. And then the other thing that's important to me anyway is that septic moving to an IA system.
Yeah. All right. Understood. I will discuss that with my client, and I think we can do that.
Okay. Any comments from members of the audience?
Mr. Chairman?
Yes, Mr. Murphy.
Yes, my name is Wilson Murphy. I'm at 43 Red Pine Drive. I'm also president of the Sandy Shore Association, and it's in that capacity. Just want to give you a heads up. The lot in question is part of the Sandy Shore Association, and the association has a number of bylaws and deed restrictions, and one of those deed restrictions is that the design plans and site plans has to be approved by the board or me before we can go on to comport with design factors such as a Cape Cod house or a colonial house with slopes of the roof and that kind of a thing. So I'm not sure we're talking apples and apples here or apples and oranges, but in addition to the considerations here tonight by the commission, we also will have our approval processing coming in. So if we make some changes or some changes are made, that will start the our clock all over again as well. Mr. Letty and Amy are both aware of this. I emailed Amy on this, I think, on the 29th of March. And so as far as I can see, all our T's have been crossed and I's have been dotted in terms of information.
All right, thank you. I'm not sure how that does connect to the Conservation Commission, but maybe you can have a discussion with the proponent.
He was a little broken up. Is there a meeting on any time frame, monthly or quarterly or anything like that the association has?
The association itself has an annual meeting where the members discuss items of importance. But as far as the board is concerned, that happens on an irregular basis when the need arises.
All right. Yeah, I guess, I could follow up with you. My client could follow up with you. I think you've actually talked to him before a couple times. And we could figure out a way to arrange any review that might be needed.
Yeah, yes, I have spoken with him a number of times, and he has a copy of the restrictions and the bylaws and all those types of things.
I will review those with him, and we'll be in touch.
Thank you.
Thanks.
All right, any additional comments from members of the audience?
I don't know, can you hear me?
Yes.
I actually I own 30 Red Pine, and I think the engineer made a mistake there. He said that it wrapped round 38 Red Pine. That's wraps around 30 Red Pine. And my problem with it is I see this retaining wall there that's covering the leaching fields. It's right up against my my backyard. I don't understand how this house can be built there in the first place, but that's looking right into my kitchen. Like, so he's raising the thing to work the leaching field right into leaches. Where's it going to leach? If it's above ground, yeah, he has it covered with a stone wall, but it's higher than my property.
That area is being cut down, so that we're cutting that down below grade from where it is right now. That area is going from elevation 103 down to 98, so it's going down a few feet, and that's being done to level out the front yard, and then the leaching field will be there. So there will be there's no chance for breakout there. We meet there's a 15-foot requirement. There's a 15-foot requirement there from the elevation of your system. 15 feet out, you cannot daylight that elevation 15 feet out. We meet that breakout requirement. So there's really,
I don't know, but building a 2,700 square foot house in someone's backyard is not right. It's not right at all.
Well, it does sound like you have a...
Like it's right on top of my house.
Yeah, but it sounds like it's a building department.
Yeah, I understand that, but I'm not up on all this wetland stuff and stuff like that, but I don't like what I see there. Simple as that, so. And I think a good few of my neighbors are the same way.
Well, I appreciate you hanging on to have comments tonight on this. We are going to continue this. It sounds like you probably need to look into some, either building department codes or zoning, but because it doesn't sound like those are conservation issues that you are bringing up.
Yeah, no, I appreciate that. I understand, Jeff. Thank you.
All right, well, thank you for your comments. Let's see, any other comments from members of the audience? All right, hearing none, when would you like to continue until?
I think we can we shoot for the 21st? When do I have to have revisions back to you by? 1 week?
I think it's a week.
Okay, I think we can do that. If we can't make it, I'll just request a continuance.
Okay. All right then, so I'm gonna go ahead and move that we continue the notice of intent hearing for 34 Red Pine Drive, map 82, parcel X18 until April 17, 2021. Have a second?
I'll second.
All right, seconded by John. Do you have any discussion, Karen?
By the date,
I was gonna say, I think you got the wrong date.
The
Did you say
date.
the 17th?
21st?
April 21st.
Is it 21st? Let me check my calendar.
14.
That's the 21st. All right, did I say the 14th?
I thought I heard the 17th, but.
These things happen after 10 o'clock, don't they? I'll amend my motion to continue the hearing until April 21st,
And I
2021.
amend my second.
Thank you, John. All those in favor say aye by roll call, starting with Mark.
Aye.
Jim.
Aye.
Carolyn.
Aye.
Ernie.
Aye.
Stan.
Aye.
John.
Aye.
Myself, Brad Chase, aye. The motion carries 7-0. Thank you all for your time, and we'll see you on the 21st. Okay. All right, I'm going to read the next two hearings which have been continued. Notice of intent for 64 Snowen Road, Realty Trust 0 Snowen Road, map 15, parcel N8-B-0-R. Proposal for a pier ramp and float and dredging. The applicant has requested a continuance until April 21st, 2021. I move that we grant that continuance. Could I have a second, please?
I'll second.
Seconded by Carolyn. All those in favor say aye by roll call, starting with Mark.
Aye.
Jim.
Aye.
Carolyn.
Aye.
Ernie.
Aye.
Stan.
Aye.
John.
Aye.
And myself, Brad Chase, aye. The motion carries 7-0. Next, we have a notice of intent for 30 Harbor Road, map 15, parcel 15-A, proposal for a dock. The applicant has requested a continuance until April 21st, 2021, and I move that we grant that continuance. Could I have a second, please?
A second.
All right, seconded by Carolyn. All those in favor say aye by roll call, starting with Mark.
Aye.
Jim.
Aye.
Carolyn.
Aye.
Ernie.
Aye.
Stan.
Aye.
John.
Aye.
And myself, Brad Chase, aye. The motion carries 7-0. So that concludes our notice of intent. Can you imagine how this meeting would be if we didn't have the earlier RDAs and these notices continued? We'd be here till midnight. All right, next we have a show cause hearing for clear cutting of wetland vegetation at 0 Standish Woods Circle, map 116, parcel C5-65. Do we have a representative here tonight for this?
Yes, we do. My name is Barbara Gannon, and I am the president of Standish Woods Homeowners Association. And with me tonight are Pat Bowler and Carol Ann Whittle, both of who are directors on the board, along with being members of our Green Space Committee.
Well, thank you.
If I may please just take, I would like to take just a couple of minutes, if I could, to inform the committee what we have done after receiving the letter that there had been cutting of plants on the wetland edging Mud Pond. We were very surprised about this event, and actually our own bylaws and covenants support conservation. The first page of our covenants includes this statement: that one of our missions is preserving and protecting the natural character of the land, conserving the trees, the shrubbery, and other natural features for the benefit of all property owners. Therefore, any request to alter the landscape to the board would have been denied. And when there is a turnover of property in the neighborhood, we have been very diligent to present these rules to all new owners. And it is noted at this time to the committee that Mr. Henn, who was mentioned in the letter, is not a member of Standish Woods. Our Green Space Committee was formed at the end of 2017, and it distributes newsletters and reports at our annual meeting, sharing with everybody a color-coded map of the green space and conservation land, which we have paper documentation if the committee needs it for any type of investigation. We have taken this cutting on the wetlands very seriously, and we have tried to find an answer to the destruction. However, we have yet to find any conducive evidence as to the persons involved. We would like to share with you, however, that many people not from our neighborhood, especially this year of COVID-19, are walking and jogging, walking their dogs, and maybe using Mud Pond. Also, please note that access can be had to Mud Pond without crossing Standish Woods property. We are an ungated community with public town roads and 38 acres of unoccupied land. We cannot be watchful of all this property 24/7. We are not a police force. After your letter was received, I have personally spoken to all abutters mentioned on the letter, sent emails to them, and sent plot plans and details for attending tonight's meeting. We have not come up with an answer to this situation. And at this time, I would like to request the name of the person that reported the cutting to the Conservation Committee. If we at least could zero in on the timing of the cutting, it would help solve the mystery. We have also placed a no trespassing sign at the path on Martha Eaton Court that leads to the pond. As stated, we have been diligent in our efforts to solve this problem. And without further information from the observer, our hands are almost tied. We would ask the committee to please take note that wetlands described in your letter are accessible to outside persons not in our association. And before the committee takes action on this case, we would like to enumerate that on receiving your letter, we promptly have taken action. We have intended and have our internal regulations prohibiting this type of cutting. We have spoken to all abutters, and we have posted a sign against trespassing. We ask for a period of grace to further study the situation and to see if some of the vegetation will regrow, mainly the button bush. This being done with the understanding that the Standish Woods Homeowners Association will monitor this area more closely in the future. And we thank the committee for the time they have given to us to review this matter.
All right, thank you for coming before us. Thank you for your time waiting for your chance and for the explanation. we don't have the conservation agent with us tonight, so we really can't give you information on how this came before us, but we will catch up with you on that later. And we will ask the Conservation Department staff to follow up on that as soon as they're able. So I don't think we can do much.
Sorry.
Yes.
Can I request people to please wait? There's an awful on the line.
Yeah, I think Ernie's mic has been, okay, that seems to have helped. So, yeah, I don't think we can do much else with this tonight. So I will ask if there's any comments from the commissioners, but I don't think we'll be able to resolve too much without more information. So does anybody want to say something in particular? I'll start with Mark.
Oh, I have no remarks.
Okay, Jim.
Yeah, just to clarify, does the association own the property in question?
We owned the open space, and of course, the wetlands 10 feet from you have jurisdiction over the wetlands that borders the pond.
Okay, yeah, well, that sounds like the association owns the property. I mean, it seems like obviously this wasn't done on purpose by the association.
That's correct. We were broadsided by somebody, yes.
I mean, I think at the very least, moving forward, we would want to see some very thorough signage to make sure people aren't trespassing in there and doing any sort of cutting. And I haven't had a chance to go down there, but at the very least, some signage and some consistent reporting to Amy to make sure that's growing back. But I think we might have to hear more from Amy to really resolve this. That's my comment.
Thanks, Jim. Carolyn?
I have no comments.
Ernie?
Yeah, just a couple of comments. One, as to the timing of the cutting, I think it was fairly clear. We went down and we looked at the property, and the property behind two houses on Martha Eaton Court, I believe it is, it's fairly clear that the cuttings benefited their view, their corridor view to the pond down there. So, I mean, I would strongly suggest the associations speak with those two property owners. The property that was somewhat removed from that to the west of that, I believe it's behind Standish Woods Circle, that looked like it had been cut quite some time ago. Might have been maintained for the corridor view, but I think that was something which has happened sometime in the past. So that might be able to help you. Again, the two houses that had that corridor view, that was fairly recent, and I think you can tell just from the cuttings that are stacked up next to on each side of where they were taken out is fairly evident. You mentioned that the property is accessible to outside persons. I would urge you not to go down that path, because someone from outside the association, they have no incentive to cut that specific area of bush. So I don't think that that's a reasonable expectation that someone came in and nefariously cut that just out of spite or something. So I would suggest that the association focus on the property owners that most benefit from that work that was done along the banks there. That's it. Thank you.
Stan?
Yeah, I kind of agree with Ernie's comments. I can't see somebody from the outside coming through and cutting that large of an area without
somebody noticing it with homes around there. So, yeah, I have nothing else.
All right, John.
Yes, I agree with the previous two comments. It's hard for me to see how that cutting could have gone on unnoticed by people in the neighborhood. You know, it's either one of the abutters, and that is a pretty big chunk of land that is in a separate lot from the lots with houses on it, but it stands directly between a couple of those houses, as Ernie pointed out, and the pond. So I think that we have to wait to talk to Amy about what reasonable steps are to be taken to remediate the situation. But either the homeowners who did the cutting or the association is going to be responsible for whatever steps need to be taken.
All right, well, thank you. You heard these comments, and so we do need to circle back to the conservation agent and discuss this with her, and then she'll be in touch with you, and you guys can trade information on what you've learned in the meantime. So thank you again for coming in tonight. Any final thoughts that you have for us?
No, except thank you for your time. And I hope that we can come up with a solution that will take care of it and prevent it from happening again.
I agree, and we look forward to trying to find that solution with you. So thank you, and have a good night.
Thank you. You likewise.
Okay. So next we have two orders of condition. The first is for 4 Eastern Avenue, map 6, parcel G3-8. It was a removal of existing house, deck, septic, and construction of new house with patio, landscaping, and septic system. I would say if anyone has any edits or comments, just go ahead and speak up. I don't have any comments on this order.
I do, actually.
Okay.
Under special conditions number 4, no fertilizers, herbicides, or pesticides shall be used within the wetlands or 100-foot buffer zone, not with the 100-foot buffer zone. Within. Okay. And number 5, no. And further in number 4, it says this includes organic fertilizer, which does still include nitrogen and phosphorus. Can't we just say this includes organic fertilizer and not get into the properties of the organic fertilizer? As long as we say specifically this also includes organic fertilizer, they can ask if they have questions. That's just a thought. In-ground irrigation is permitted to remain in the location occurred. Let's see, 5. Sorry. Only in-ground irrigation is permitted to remain. I would put in only in the location it currently exists. Now let's see. These are just thoughts, though.
Well, Melissa's she's listening to make edits, so I think we just need to be clear what she should make changes on.
Okay. Number 9, I had a question. Any lawn area on the property is to be composed of native grass seed mix. Turf or sod is not permitted. Are we absolutely sure that we will never permit turf or sod?
It's in our regulations.
Okay, good. And number 11, I had a question just reading this saying no mulch is allowed in the mitigation planting areas. The areas are to be left to naturalize. But then we say you could seed them with native grass seed or native wildflower mix. Is that letting it be naturalized if you seed it?
It's a good question. I can't recall what we ruled on.
The same questions the same exact questions are in the second order of conditions also. Those sentences, same in both.
I believe the intent was that in doing the mitigation plantings, wildflower mix and native seed mix can be applied in between the shrubs, but then the entire area must be left to naturalize from there forward.
And isn't that a necessary thing to stabilize things? It's instead of mulch to just try to hold things together while the other plantings get established and begin to mature. So it doesn't seem contradictory to me.
Okay, I'm fine with it. Those were my thoughts on both of them, actually.
So I actually have a question about number 4. I thought that we had standard language about fertilizer pesticides, and why are we having to find typos and start to parse this out? It ought to be a total cut and paste operation here. I'm not sure what the issue is.
It's like someone else wrote them.
Yeah, well, maybe Melissa put them together or something. I don't know, but we ought to make sure, we ought to, another night, when it's not after 10 o'clock, once again, agree on the common language that will always go in there and
Exactly.
have these conversations.
Exactly.
Yep, no, I think that's right, and I think it's probably, it probably is a transition from Nikki, leaving and Melissa stepping up, so that's a pretty easy point to make, and we'll just get, standardized language for these conditions.
Mm-hmm.
Anything else for that first one? Okay. Well, I'm going to move that we approve the order of condition for 4 Eastern Avenue, map 6, parcel G3-8.
I'll second.
Seconded by Carolyn. All those in favor say aye, starting with Mark.
Aye.
Jim?
Aye.
Carolyn?
Aye.
Ernie?
Aye.
Stan?
Aye.
John?
Aye.
And myself, Brad Chase, aye. So motion carries 7-0. Next, we have an order of condition for 7 Prince Charles Drive, map 110, parcel S26. Construction of a second floor addition to the existing dwelling and expand the existing deck to include a proposed porch area. If anyone has any comments or edits, please just speak up.
Again, number 4 should be within. And the question is, do we want to delete the explanation of organic fertilizer?
I think that's a good idea. Any other comments? Right, I move that we approve the order of conditions for 7 Prince Charles Drive, map 110, parcel S27. All those in favor say aye. I'm sorry. Seconded by Carolyn. All those in favor say aye, starting with Mark.
Aye.
Jim?
Aye.
Carolyn?
Aye.
Ernie?
Aye.
Stan?
Aye.
John?
Aye.
Myself, Brad Chase, aye. Motion carries 7-0. Okay, we have 2 requests for certificate of compliance. In both cases, we have recommendations for approval from our conservation department. I would like to see if there's any comments on both of these and just approve them in one motion. It seems fairly straightforward because we have a recommendation for approval. Does anybody have any concerns or comments on these? I guess I should announce them. The first one is 112 Clearwater Drive, map 63, parcel A-102, SE 32-1065. There was a septic installation. And the second one is 112 Clearwater Drive, map 63, parcel A110-102, SE 32-319. And this was for a 12 by 12 deck with a 5-foot walkway with storage underneath.
So I have a question.
Yeah.
They're the same address, same lot number, different SE numbers and different people. I don't understand.
Yeah, I just noticed that.
It could have been done different times. They were probably done different times, and the people maybe selling the property, and they want to clear this up now. That's possible.
Okay.
Well, I'm going to make a motion that we approve both certificates of compliance for 112 Clearwater Drive. Have a second, please.
I second it.
All right, seconded by Stan. All those in favor say aye by roll call, starting with Mark.
Aye.
Jim.
Aye.
Carolyn.
Aye.
Ernie.
Aye.
Stan.
Aye.
John.
Aye.
And myself, Brad Chase, aye. Motion carries on both, 7-0. Well, I don't think we have any minutes. Any new business? Any announcements?
Nope. Nope.
I know, I'm sure hungry. Wow, another busy one. All right, folks, well, thank you very much.
Oh, Brad, do you know how Amy is?
Yeah.
I haven't heard. I haven't heard anything from her. You know, she's got to be out of.
Heard anything? Melissa, have you heard anything?
I'm not sure.
Well, other than when I texted her yesterday, just a 1 or 2 line text, and she came back and said all went well and she's recovering. So
Okay, good.
Good.
Okay, so if she's watching sometime ever for this recording, we send our best.
Yes.
Yes, I second.
Speedy recovery. All right. Well, I'm going to motion that we adjourn.
I second it.
All right. Thank you. All those in favor say aye by roll call, starting with Mark.
Aye.
Jim.
Aye.
Carolyn.
Aye.
Ernie.
Aye.
Stan.
Aye. And remember, we started early tonight, too.
I know. John.
Aye.
And myself, Brad Chase, aye. So we are adjourned.
Okay,
Yeah,
Brad, is Melissa going to contact us as to when we should be